Welcome to AT&T's Teleconference service. Please enter your access code, followed by the pound sign. Your access code was not recognized. Please re-enter your access code, followed by the pound sign. To join the conference as the host, press star. Otherwise, press pound. Please enter your host password, followed by the pound sign. There are 1 participants on the call, including you. You are joining.
It is a lot of us. All right, good morning, everyone. It's Thursday, November 16th, 2023, and this is the regular meeting of the California Fair Political Practices Commission. Ms. Contreras, would you please call the roll?
Commissioner Ortiz?
Here.
Commissioner Baker?
Here.
Commissioner Wilson?
Here.
Commissioner Wood?
Here.
Chair Matich?
Present. All right, let's go ahead and proceed with item 1. This is public comment for items not on today's agenda. Do we have any public comment for things not on today's agenda? Hearing and seeing none, we'll proceed to item 2, approval of the October 2023 Commission meeting minutes. Do any commissioners have edits or comments on the minutes? Commissioner Baker?
This is just more for disclosure. We had the minutes updated before from what was originally posted on the website, just to reflect a few minor changes about when I departed the last meeting that was in Fresno, and then the vote totals. So just with that acknowledgement, move to approve the minutes.
All right, I will second. Any public comment? Hearing and seeing none, Ms. Contreras?
Commissioner Baker?
Aye.
Commissioner Ortiz? Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
Motion passes.
All right, we'll proceed now to our consent calendar. Those are items 3 through 6 today. Do any commissioners wish to pull an item from the consent calendar for separate discussion?
Yes.
Commissioner Ortiz?
6.
Item 6? All right, any other items? Commissioner Baker?
Yes, item 4, please.
Item 4? Commissioner Wilson? Commissioner Wood, anything? All right, so the remaining consent calendar today are items 3 and 5. Well, let me ask Chief of Enforcement, Mr. Lindsay, did you have any comments you wanted to make before we proceed to vote on the consent calendar on either item? All right. Well, let me just say before we proceed to the vote that I think item 3, for my part, I was impressed by the staff's work on that case and the content of the stipulation. I thought it was well written. I think the penalty was absolutely appropriate. So I just wanted to take a moment and recognize staff's work on that particular stipulation, which involved unlawful political mailers by local governments, which has been a focus of this commission. So appreciate staff's attention to that. Commissioner Ortiz, were you going to make a motion on the consent calendar?
Motion to approve.
All right.
Second.
Any public comment? Hearing and seeing none. Ms. Contreras?
Commissioner Baker?
Aye.
Commissioner Ortiz?
Yep.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
Motion passes.
All right. We'll proceed to our separate discussion. First of item 4. This is a default proceeding in the matter of Bill Bro, State Assembly 2018. Commissioner Baker, you pulled it. I have some comments as well, but why don't you go ahead and kick us off?
Yes, and a couple of points here. One is to focus on what is before us, which is not the underlying original stipulation. It's the whether and the default action to pursue in light of breach of the, I want to call it a payment agreement, but the agreement plan. I also wanted to highlight one of the facts in here was pointed out to the commission by a random audit, which is a reminder. I know we'll talk about audits and the importance of them happening later today, including in our legislative agenda, but it's a reminder why our random audit program is so important. I pulled this, however, because I wanted to ask a few questions about what's the maximum that we can do, given that we're not approving the underlying stipulation, we're weighing in on the default proposal for breach of the payment agreement. I don't know if that's the right terminology for what that document is, but my understanding is $90,000 has been proposed by your team. What would be the maximum that we could approve as breach of a default? And I don't mean based on the number of counts that are in the underlying stipulation, but since the breach of the agreement has happened, I understand that we can add more. We can add even more than $90,000 to this, to the penalty that we would potentially be approving today. Can you address that, what the maximum would be, and not necessarily based on the stipulations counts, because I know there's usually math, but that's my first question.
So, thank you for that question.
Took me a minute to land on it, but
I just want to clarify.
Clarify it. Go ahead.
Your question is, what is the maximum that we could do within the confines of the default proceeding?
correct. That we could, that's why, I don't think 90 is the maximum. I'd like to know what the maximum is.
Yes, and that's how I understood your question. The maximum under the default could be $100,000. Because there are 20 counts, $5,000 is the max. The commission would have the authority to charge $5,000 or penalize $5,000 per count for an aggregate total of $100,000 if we operate under the default.
Okay, and because my understanding from the default, I'm calling it the default, that's not right. The payment agreement is that we can add more counts. The answer you just gave me is here's the number of counts that have been charged, multiply that times 5,000, that gets us to 100,000. But I understand if Mr. Bro breaches our agreement, which he appears to have done, we can actually add more than what the counts are. Is that correct?
So let me back up a little bit just to make sure I understand and can give a full answer here. We negotiated a mainline settlement that used 10 reporting violations as aggravating circumstances only.
Yep.
Within the agreement and his waiver, if he were to not follow through with the payment plan, the agreement was that we could charge up to 10 additional violations for the reporting violations that were only mentioned in the main line as aggravation and not specific counts. So if we move forward with the agreement and the default, then the maximum that could be done is $100,000. We've recommended $90,000, but the maximum that could be done is $100,000. Theoretically, if we scrapped everything, we could go back to square one and we could charge additional counts, not for the reporting violations as I understand it, but there were additional instances of misuse, misappropriation that theoretically could be charged as additional separate counts, but that isn't how we approached this in this particular matter.
Okay, I think what I'm hearing is $100,000 plus another potentially $50,000 for the uncharged, unless I'm doing my math wrong. Or maybe it's up to 10 additional.
Yes.
That's an additional 100,000.
Yeah, so we are still capturing the first 10 counts that were in the main line that are being charged. So the misuse, of assets and funds, those are being charged now just the same as they were in the underlying main line, although the requested penalty under the main line was only $47,000, but now it's $50,000. The additional 10 counts are for reporting violations that were mentioned, not specifically, but mentioned generally in the main line that we are specifically charging now as authorized under the waiver and the default.
Thank you. The reason I'm asking is because I know we are not weighing in on the underlying stipulation, but those facts are in the record. And for my almost now 3 years on the commission, they include some of the most egregious conduct and the highest level of public harm and abuse of trust that I've seen. And I will welcome my colleagues' thoughts as well as yours on why we wouldn't take, since the payment agreement says, hey, if you default, we can add even more claims, why we wouldn't add more claims accounts to the penalty.
Yeah, I think, Mr. Lindsay, can you clarify? Because I want to make sure we're very clear, not conflating increasing the penalty that's proposed in the recommended default as
Right.
opposed to adding additional claims. As I understand it, you have already added the additional counts
Yeah.
authorized under the repayment plan. The only question for purposes of this default recommendation is, do we increase the penalty amount? But you tell me if I'm misunderstanding that.
You're absolutely correct. We are charging everything that we can charge pursuant to our agreement. And that included these additional 10 charges for reporting violations. And so therefore, the requested amount under the default, under this process, is $90,000. Okay.
I'm getting the math right now. Thank you. As always, the chair clarifies my thinking, so I appreciate that. Given that it could be 100,000, and that's the maximum we can do, and these are the most egregious facts, at least again, that I think I've seen. There's some of the highest degree of harm that we've seen with what appears to be intentional obstruction and falsifying information to us in the course of our own investigation, and many things that made our investigation harder. I would support the largest, I want to use the word penalty, for the breach of this agreement. Again, I'd like to hear my colleagues on that, but
Thank you, Commissioner Baker. I agree wholeheartedly that this is, first with your observation, this is some of the most egregious conduct we've seen since I've been on the commission. Intentionally misusing campaign funds for personal gain has been a priority for this commission, and it really strikes at the heart of what the act is intended to prevent. I also, just for my own piece, setting aside the egregious nature justifying max penalties across the board for every count, I cannot help but make at least some reasonable inference from the facts in the proposed stipulation, or the exhibit, I should say, in support of the default. And on page 4 of Exhibit 1 in support of the default, it records that after staff, I'm sure, spent a significant amount of time negotiating a repayment plan with this respondent, who's a sophisticated actor, who'd been in the legislature for a long time. After spending that time coming to an agreement, we held up our end of the deal. He began to make repayment plans. He made one payment. And then, interestingly, on page 4, it references that he was made aware of a conversation this commission had in April of 2023 with respect to our collections procedures. And it was after that he chose, apparently, to stop making payments. And what's interesting to me about that timing is it's in April when this commission learned that we've historically had some difficulties with collections, that in fact, things that go to collections, we only recover less than 3% of it. So I think one inference is the respondents saw that we're not very good, at least at that time, making good on collections. And so he made the conscious decision not to follow through on this agreement because he thought he wouldn't have to pay as much. I think that's a reasonable inference. At least that's an inference that I'm comfortable arriving at. Since that time, this commission has adopted more robust collections procedures. And so I believe now Ms. West, who we've delegated collections authority to, has the tools to ensure that in this case, we collect 100% of whatever amount that we put forward with respect to default. So I hope this can be, at a minimum, be a learning lesson, perhaps for other respondents who think that avoiding a stipulated agreement, you're going to get a better deal going through collections. That's why we took the action we did to bolster our collections efforts. So I agree, subject to what my colleagues say, that we should increase the penalty here to $100,000. But Commissioner Ortiz, Commissioner Wilson, anything? No, Commissioner Wood, any thoughts, comments?
I agree. Thank you for that.
All right, then I will make a motion that with respect to item 4, that we modify the proposed default to increase the penalties for counts 11 through 20 from $4,000 to $5,000 each, so that the total default amount is $100,000.
second.
Well,
Oh, sorry,
almost,
you weren't done yet.
almost. Secondly, that this commission direct Ms. West, pursuant to her new collections authorities, to make this a priority matter for collections purposes and to pursue any and all means at your disposal to ensure that we recover the full measure of this default.
Second.
Any public comment? Hearing and seeing none. Ms. Contreras.
Commissioner Baker,
Aye.
Commissioner Ortiz.
Yes.
Commissioner Wilson,
Aye.
Commissioner Wood,
Aye.
Chair Matich.
Aye.
The motion passes.
Thank you. All right, moving to item 6. Commissioner Ortiz, you had asked for a
Yes,
separate.
thank you. On page 3, there's a list of people who should file the Form 700, but I don't see special districts.
Are you looking at the Form 700 document specifically?
Yeah. Who says, official, item 1, officials and candidates specified by government to file the Form 700.
Who must file? So special districts, it's depending on the conflict of interest code. So those are called designated code filers. So special districts, if they're enumerated in a conflict of interest code, they'll be filing under 87300. And a lot of who we have on our forms are for 87200 filers and candidates and state office holders.
What's the difference between the two of them?
87200 are usually, we like to say, the ones that are enumerated in statute that are making decisions regarding public funds and investments, and they're subject to the strictest and most broadest disclosure under the Act. Code filers have a code that will assign disclosure categories to them that are tailored to what they need to report depending on their position and their decision-making authority. So special district folks usually do need to also file, but we usually refer them to their agency's conflict of interest code, which will define what they need to file.
Really? I was a member of a special district, and I filed Form 700s every year, so, and as I recall, it's the same one that I used to file when I worked for the legislature.
It's the same form, but depending on what agency that you work for, or if you're an elected official, so if you're an elected official and you're a city office holder, like a mayor, city council member, you're filing under 87200, which is everything you need to disclose, every type of category. And then 87300 filers are code filers, and that will fall into the conflict of interest code. And so someone that may be staff at the special district may have different reporting requirements than a board member at the district and may have to disclose different items.
If I may, code filers are included under the paragraph 2 on page 3. Those are the code filers. Paragraph 1 lists 87200 filers that have to file. The subparagraph 2 states that all agencies have to adopt a conflict of interest code, and anybody designated in those codes have to file pursuant to those codes. So they are covered on the paragraph 2 here.
Okay, thank you. Yeah, I was wondering whether I wasted my time.
We really care about disclosure, so.
All right, any other questions? Mr. Lau, my understanding is there's one technical change that you wanted to highlight for us?
Yes, on page 2 of the same reference packet, we have identified a typo. The $590 gift limit applies for 2023 to 2024, and it currently states 2022 to 2023. So that's already been corrected on the online proposed document here, and that will be corrected before final printing.
What page was that?
That's page 10 of the reference pamphlet.
Any other questions for Ms. Hackert? All right. I would then move to approve the SEI forms presented in item 6, subject to the correction that Mr. Lau just outlined on page 10 of the reference pamphlet. Is there a second?
Second.
All right. Any public comment on item 6? Hearing and seeing none. Ms. Contreras.
Commissioner Baker,
Aye.
Commissioner Ortiz.
Yes.
Commissioner Wilson,
Aye.
Commissioner Wood,
Aye.
Chair Matich.
Aye.
Motion passes.
All right. Thank you, Ms. Hackert. We'll now proceed to our general items, and first up is item 7. This is a motion to vacate a default decision in order in the matter of Jose Peck. Mr. Lau, I know you have some opening brief overview of some procedural aspects for us, and then we'll turn it over to Mr. Lindsay.
Okay. As stated, this is a motion to vacate. The default judgment was approved by the commission on September 3rd and served on the respondent on September 23rd. The respondent mailed the motion to vacate around October 12th, which is around 19 days after the service. Under commission regulations, a motion to vacate must be filed within 7 days, so this matter may be denied solely on procedural grounds and the untimely motion. To the extent the commission examines the merits of this motion, the regulation allows the commission to vacate a default judgment upon a showing of good cause. As that term is defined under Government Code Section 11520, that's defined two ways. One is inadequate service, which has not been claimed here, or for a mistake, inadvertence, surprise, or excusable neglect. And just to elaborate on that standard a little bit further, California courts have defined excusable neglect as whether a reasonable, prudent person under the same circumstances would have made the same error. And with that, I'll turn it over to enforcement to go into the specifics of the actual case.
All right. Thank you, Mr. Lau. Mr. Lindsay?
Thank you. Yes, indeed. This motion is both procedurally and substantively defective. It's too late for consideration. And more importantly, I would say it doesn't address the standards that are necessary for granting the motion. There's no excusable neglect here recognized under the law. There is no allegation, much less establishment, that he didn't receive the accusation or anything else relating to the case. He just chose not to participate. Ultimately, the decision, the default was taken, and apparently he, is unhappy with the results after making a conscious decision not to participate. So we would ask that the commission rule that it's late, not and procedurally defective, and deny it on that basis. But if the commission wishes to look at the merits, it's also not meritorious.
Thank you, Mr. Lindsay. Ms. Contreras, do we have Mr. Peck on the line? Has he indicated that he's going to participate? Mr. Peck, are you with us? All right. Apparently not. Thank you. Mr. Lindsay, I had a question for you. In the motion, if you will, to vacate the judgment, Mr. Peck writes that he had requested information from Ms. Reinhardt, one of our staff members, which I did not receive, nor was it addressed. Can you address for us whether that's true or not?
It's technically, he did not receive the documents that he requested, because at the time they were requested, they were pursuant to subpoena, and we were unable to release those documents. However, he did receive a complete log describing all of the documents in question, and if he had participated in the lawsuit or the administrative action, he would have received those at the time that we were able to actually provide those documents.
All right, so we did respond to his request for information. It was a limited response necessitated by the regulations. Is that right?
Yes, that's correct.
All right. Do other commissioners have any questions or comments for Mr. Lindsay? Commissioner Wilson?
Yeah, Mr. Lindsay, the memo of October 26, 2023 goes into a lot of detail, and it's well done. Could you respond to Mr. Peck's statement or allegation that, since he had filed, SCI 2 months earlier, it in effect would be the same as the end of office SCI that he'd be required to file? And could you just touch on why it's important to file that SCI upon leaving office, and why that's important regardless of what prior SCIs you might have filed?
Well, it's specifically important in this particular matter because, as you may recall, there was a conflict of interest scenario involved here. It was unusual in the sense that the conflict of interest code incorporated his position very shortly after before he left office. But, he did not timely file those SCIs, and those were charged specifically in the default as well.
Thank you.
Any other questions? Commissioner Baker?
Thank you to my colleagues for asking those questions. I also would like just to give you a moment to address one of the other points that's raised in the motion, and that is in his first full paragraph, that he was aware of the hearing back in June, it was postponed, rescheduled, postponed, and finally rescheduled, just to go to, any sense of good cause there. Can you address that allegation or explain the circumstances?
Well, we notify respondents throughout the process, through the pre-notice and default process. He was notified many times of the process, as was indicated in the default papers itself. We had been in communication with him throughout the process. I think there was close to 50 communications with him over the course of time. He's acknowledging that he was aware of the hearing, and he wasn't there. He wasn't there for the pre-notice. He wasn't there for the default judgment proceeding. He's not here today. So in the end, there's apparently some form of complaint, but there's no participation. And that's all I can really say about that.
Thank you.
Commissioner Wood, I think I saw you raising your hand.
Yeah. I'm getting it. Sorry. I'm curious about this. I don't want to put facts in this case, and so I just kind of have a general curiosity here that does not need to be particularly related to this. As I was reviewing all of this, I can't find it now because the document's kind of long, but it seemed like the city did tell, or Oxnard, right, as the city, did tell him to fill out this SCI form when he separated. But then I thought I saw mention that neither, I know he didn't, but also didn't his supervisor or the person reviewing his determinations also fail to file? Did I see that in this document? And the reason I'm asking is, I wonder if there was some procedural flaw within the city that was not letting people know that it was that important to do this. I don't want to make up facts here. I'm just curious as to what we would do in a case where we knew that to be true. And I'm sorry to bring it up in the context of this case. It's just that it got me thinking that, you can imagine that maybe not this guy, but some people would just get kind of, I don't know, imperfect advice upon separation. And would we hold them accountable for that, or would we, wait for them to provide facts and then go more lenient on them? It was just a curiosity that I had that could apply in future cases.
We would look at any factors in any case on a sort of case-by-case basis. In terms of whether or not there was evidence of a wider spread problem here, we certainly aren't aware of that evidence. We undertake, and I'm not the best person to speak to this, but we undertake significant educational efforts with filing officers and whatnot. I don't know if there's been any contact specifically with the city of Oxnard. In this case, there wasn't any specific contact in this case. I don't believe on that one, but I don't believe that there is any widespread detail that you are questioning about.
Yeah, and we would probably see that there would be a lot of missing SEIs from people who departed their service in Oxnard if it were really a systematic problem there. It just prompted that question, so I appreciate your answer. I'm sorry to ask something that was a little bit out of left field there.
Not a problem. Yes. Yeah, we do refer them to education. If I didn't articulate that completely, I apologize.
Thanks.
Thank you. Any other commissioners have questions for Mr. Lindsay? All right. Once again, I'll ask Mr. Peck, are you on the phone? Do you wish to comment on this matter? We're on item 7. This is the motion to vacate our default decision. All right. I'll do that after the motion. Okay. I just want to give him a chance before we make the motion. Well, based on the record before us, I move that we deny the motion both as being procedurally defective and not raising a valid or a persuasive substantive basis. Do I have a second?
I can second that.
Oh, Commissioner Wood.
Any public comment on the motion? Hearing and seeing none. Ms. Contreras.
Commissioner Baker?
Aye.
Commissioner Ortiz? Yes. Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Okay, thank you, Mr. Chair and Commissioners.
Proceed next to item 8. This is proposed amendment to Regulation 18202. This relates to quasi-legislative administrative action and the California Citizens Redistricting Commission. With us is Commission Counsel, Ms. Nuding. Good morning.
Good morning, Chair and Commissioners. Valerie Nuding, Commission Counsel, here to present to you amended Regulation 18202, which, as the Chair stated, addresses the definition of quasi-legislative administrative action. This is a fairly straightforward amendment, so I'll keep things pretty brief, but I do want to give a quick summary of the regulation. As noted in the memo, it was brought to staff's attention that there was some confusion about whether the California Citizens Redistricting Commission could be lobbied due to the unique function that the agency serves, as well as the unique formation of the agency. When deciding how to make that clear, we determined that the confusion was likely whether the actions the agency performs were the types of actions contemplated in the lobbying rules and regulations. And just to give a quick refresher, lobbying is the attempt to influence legislative and administrative action. And here we're looking at administrative action, which can be many things, including drafting rules and regulations, and as well, but it also encompasses quasi-legislative administrative action. While the Act doesn't have a definition for quasi-legislative proceedings, and our regulation only says what is not, currently only says what is not quasi-legislative proceeding, courts have held that quasi-legislative proceedings can be generally defined as acts that adopt rules of general application on the basis of broad public policy. For example, courts have routinely found that decisions surrounding drawing lines for zoning are quasi-legislative. So here, the Redistricting Commission isn't drafting legislation or regulations, but what they do does have far-reaching implications across the entire state of California, as they're drawing district lines, which was in fact formerly a role of the legislature. Not only does this meet the definition provided by the courts, as it applies generally on the basis of broad public policy, but we can analogize the drawing of district lines to the drawing of these zoning lines. And if drawing zoning lines is quasi-legislative, then surely drawing district lines that apply and affect the entire democratic process of the state would also be quasi-legislative. So all of that is to say that the actions of the Redistricting Commission are quasi-legislative, and as such, attempts to influence those actions would be subject to the lobbying rules and regulations. And one final note is that given the confusion here was very specific to the Redistricting Commission and the importance of their role and their unique function and formation, we found it appropriate to be very specific to the Redistricting Commission in this amendment. The other issue is that this only comes up every 10 years when they're formed. So by memorializing it, they won't have to remember, and lobbyists won't have to remember what we said 10 years ago and 10 years before that. It's already there. And finally, we have made some changes since the pre-notice discussion back in September. First, we agreed with the commission, and it was a very helpful note that to make it more clear, we should state that by specifying the Redistricting Commission, we're not excluding any other state agency. We're really only doing this because they are so unique. And so to do that, we added a second sentence that says, nothing in the new subdivision applies to the determination of whether a proceeding before any other state agency is quasi-legislative. And additionally, while we were making that amendment, we realized that we had no reference to the initial subdivision that says what is not quasi-legislative. So for example, strictly ministerial actions are not quasi-legislative. So we did add a few words to the first sentence saying that a proceeding of the Redistricting Commission is quasi-legislative except what is provided in the exceptions in subdivision A. I think that with these amendments, we have hopefully made it as clear as it can be, but I welcome any questions or comments from the commission. And with that, I would submit to the commission for adoption.
Thank you, Ms. Nuding. I concur with your comments. I think these changes are very helpful. They make it about as clear as I think we possibly can, that what we're doing here is making this applicable to the CRC. I also just want to note that I appreciate staff in the education outreach efforts, references how they're going to reach out and work directly with CRC, because of course, we pass this regulation, that's great, we talk about it here, but if they don't know about it and they're not informing the public as they're coming before them, it's kind of a lost cause. So I appreciate staff doing that as well. Those are my comments. Great job.
Thank you.
Any other comments? Commissioner Ortiz?
Thank you. I apologize if I don't understand the whole thing because, I wasn't here for the September discussion. But, so I need some clarification.
Mm-hmm.
So this is, one of the bases for this amendment is because there.
You can hear me? Okay.
I can, but maybe everyone else
I know,
can.
I just saw them. So I apologize because I'm not part of the discussion. But as I understand, this is a quasi-legislative group, commission because it's statewide?
It's more so quasi-legislative doesn't have a big definition within our regulations. But the courts have said if they're adopting rules on the basis of broad public policy, that makes it quasi-legislative. And so here, what they are doing does apply on the basis of broad public policy. It doesn't have to be statewide. It happens to be here, so it's pretty clear. It can also be countywide or citywide.
That was going to be my next question.
Yeah.
So are you saying that, for example, redistricting being carried by the city, county, special district, all that stuff, and if there is somebody lobbying the members of that body, that's lobbying?
So the act only allows us to regulate state lobbying.
Okay.
What local agencies want to do, they're welcome to adopt their own rules, but we only have the power to adopt rules for state.
That's important. Thank you.
Thank you, Commissioner Ortiz. Commissioner Wilson?
I kind of have a related question that I was going to ask as a follow-up to Commissioner Ortiz's comment, and that is, in 2016, it's my understanding that there was legislation passed by the legislature that allows local governments to establish citizens' commissions. Is that correct?
Mm-hmm. I'm aware, I don't know the exact year, but I believe that they are able to do that, yes.
I read that, somewhere.
Okay.
So at least no one's refuting that that's in fact
I'm
the
not
case.
refuting that.
Given that, and as a follow-up, wouldn't it, and I don't know, we can't do this here, but I would think it would be good for the FPPC to explore, based on that legislation, whether we have the authority to adopt similar regulations that would be applicable at the local level. So I'm not looking for the answer right now, but I think that that's a logical question. I mean, given that legislation was enacted allowing local governments to establish citizens redistricting commissions, that's a question that I think would be good to answer. Would that require additional legislation? Could we implement something at the FPPC level? So it's a question that I don't expect you to answer right now, but it's one that I think would be helpful moving forward.
I can give you some brief thoughts. Maybe Brian can correct me.
I think we can answer it now. I mean, we do not have the authority under the Act to reach out to local lobbying. We would require some sort of legislation to give us more authority over the lobbying at a local level. So that is not something we can do under the Act at the moment.
I would note, though, that it will be published through our education and be sent out. So if someone feels inspired by it, that's one thing, but we can't do it.
Last question. If legislation was enacted authorizing the FPPC, then we would have the authority. Is that correct?
Yes, it would take legislation.
Okay, thank you.
Yeah, I was going to say, it sounds like we may have something to talk about later on. All right, Commissioner Baker.
Well, I'm borrowing the word from our council today, and that is inspired. That's an inspired idea, Commissioner Wilson. And it could even be just that we contemplate, I see our senior legislative counsel, Ms. Nakano, is here. If there's legislation we would support to just require that there be a lobbying rules at the jurisdiction. There's different ways to tackle it, but they're all very inspired, and I would support that. I had both comment and question. I wanted to thank the team as well for doing this because it just is going to bring great daylight to a commission that is so important. And we've had two commissions, redistricting commission cycles now, I think the 2010 cycle and the 2020 cycle. And I think it's very important that we are going to do that outreach to the CRC. Hey, we have these rules. I would like to encourage outreach also to the state auditor, because the state auditor plays a very critical role in the cut of who's going to be on the commission to begin with. And even though the auditor is not the one with the lobbying rules, but that office can be informing the prospective members, and the way they just describe the operations of the commission on their website every 10 years, the more people who know about this, the better. So that, given that we've had 2 cycles and this is going to be brand new. So I would encourage that, knowing that they aren't the ones who do it. And then will we have, are you contemplating that we would have, as part of our lobbyist disclosure training that we do already, would we include either fact sheets or just a line? Would that be included, maybe a slide for folks as well on that issue going forward? And just think about it, if it's appropriate. Yeah,
I'll make a note. Thank
the more, the merrier who know about this. But I'm very grateful that we're doing this, especially because the legislature was not able to adopt legislation, and that we appear to have the authority to do it. So thank you to my colleagues and everyone for following this through.
Thank you.
Thank you, Commissioner Baker. And I concur, by the way, with reaching out to the auditor. I think that's a great idea, so we should add that to our list.
It is on my notes.
Commissioner Ortiz?
Yeah, something else.
Thank you. When may constitute lobbying under the Political Reform Act, is a single citizen that shows up before the Redistricting Commission and he or she advocates for or against or changes, is that lobbying?
No, so for it to be lobbying, the person doing the influencing has to qualify as a lobbyist.
So you're putting the burden on registered lobbyists?
Correct, that's when lobbying happens.
Okay, good,
Yeah.
thank you. Thank you, Mr. Chair.
Yeah, of course. All right, any other comments for Ms. Nuding from the commission? Nope, Commissioner Wood?
Oh.
Sorry.
Hello.
Hi. Great job. The administrative law professor in me was very happy to think of quasi-legislative actions. And as I was reading through, my coffee hadn't kicked in yet, and I was reading this amendment, the proposed language, and it says nothing in subdivision B applies to the determination, blah, blah, blah. Couldn't it say nothing in this subdivision? I went looking for subdivision B, not fully realizing that I was in it. Could we say nothing in this subdivision? Is there a reason not to?
The reason I like subdivision B is because when you use subdivision, people aren't necessarily sure exactly which like what level of the hierarchy you're at. So they sometimes think that means A and B. They don't realize which level is the subdivision.
Okay, I'll take the L. Thank you.
Thank you, Commissioner Wood. Full disclosure, I actually had the same
You're like, where?
But I knew Mr. Lau had a very specific response. So, all right. With that, I would move approval of the proposed regulation in item 8 with respect to the CRC. Is there a second?
Second, yeah.
Is there any public comment on item 8? Hearing and seeing none. Ms. Contreras.
Commissioner Baker?
Aye.
Commissioner Ortiz?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
Motion passes.
All right.
Thank you.
Thank you. Great job, Ms. Nudie. All right, we'll now proceed to item 9. This is our, referring to it as our possible regulation projects for 2024 procedurally. The purpose of having this conversation today as a follow-up to a conversation we had Law and Policy is to determine whether there are additional regulatory ideas that the commission or members of the public may want to offer to add to our regulatory calendar for next year. This matter actually is not up for adoption today. This is something we will return to in January and finalize at that time. And then I want to make the additional point to everyone as a reminder that nothing precludes us, even when we adopt these calendars, to add regulatory ideas as we frequently do throughout the year. So it's really just a starting point to help staff start prioritizing their time. That's part of what we're doing here. So with that, Mr. Lau, any particular items you want to draw our attention to?
Yeah, you just stole the first 3 lines of my presentation. So, yeah, I would point out that, yeah, this is not a final calendar. This is just a proposal. The idea of this is to solicit ideas from the commission and the regulated community for other things that we could do moving forward, and whether or not these are ideas that are worth moving forward in your eyes. Again, this is just a starting point. This will come back to the commission in January for a final decision, but even that's not final, and that we can add to it at any time. But it does give the regulated community 2 months of this being out there, so they have an opportunity to submit additional comments. With that, I can just go through each of the, I think there's 8 of them, if we like, or is that what? Okay. So the first one on our list is we have the honorarium ban. This is directed by the commission. After this will examine the honorarium ban in relationship to a business that precedes the official being elected and regularly engages in public discussion in furtherance of official work in furtherance of work as an author or an expert. This is for those of you who were here earlier this year, this is a result of the discussion around the Winnick advice letter and the direction the commission gave at that time to move forward in examining the honorarium ban as it applied in that situation.
Yeah, sorry, Mr. Lau, in light of the fact that Commissioner Ortiz was not here at that time, can you just give us like a very brief?
Yes, it was a letter that explained how the honorarium ban under the current regulation works for an official who was elected to office but had a preceding job, work as a author and expert in several areas. So most of her current work, though, was promoting and doing public discussion of the book and the subject matter she was an expert in. That being said, the Act bans honorarium for public speaking unless it's a bona fide business, and bona fide business says that the business cannot be the predominant activity of the business cannot be speech making. So to that degree, we applied the honorarium ban and said, you're allowed to do this, but your speech making can't be more than 50% of your work through the course of the year leading up to the decision, which is what is provided for in the current regulations. So that being said, it was sympathetic in that there was a pre-existing business, so we are looking at the honorarium ban and whether or not we will be able to either maybe modify the predominant business definition or some other options that have not been identified yet, but we're just looking to provide relief in that specific situation.
I think because thank you, Mr. Chair, that I have a question about this, and since it's here, might as well ask it now. When we had this initial discussion about the ban applicable to that situation in a particular advice letter, I think where the commission left it was, can you go back and see if we can do anything by regulation or if legislation is required? Is the fact that you've put this on not you, but our legal team has put this on the regulation calendar a affirmative statement, basically, that yes, we have the ability to do this, it does not require legislation, or is that dependent on what regulations we come up with? Do we have the authority, basically? Did you reach that conclusion?
I would say, I think the regulatory authority will be based on what we do come up with. We are going to look at it from every angle that we can to see if we can come up with something that will work.
Sounds like that's still part of the conversation then.
Yeah, well, I think what I hear Mr. Lau saying is today, I'm going to put a few words in your mouth here. If today you're comfortable that the regulation that we have today is within the scope of the statute. If we want to go in a different direction than the current regulation, staff's going to need to know what direction the commission wants to go in and then can assess whether that direction is permissible under existing statute or whether that direction requires a statutory change. Is that fair?
That is fair.
All right.
Thank you.
Sorry. Moving on, the next one is transfers to interest-bearing accounts. This is a proposed codification of an advice letter that was issued last year. Generally, committees must hold all their campaign funds in a single bank account. However, we've always had a longstanding allowance for transferring money temporarily into interest-bearing accounts, just as a matter of wise investment and wise retaining of your funds or management of your funds. However, there has been some ambiguity whether this exception applies to all-purpose funds held by general-purpose committees and political party committees. And this is because the regulation states that these all-purpose funds must be deposited into an all-purpose account, and that transfers to any other account is forbidden. You may not transfer to any other account. That being said, staff had advised that we never intended to restrict these temporary transfers into interest-bearing accounts as a matter of managing the money. So this proposal will add that to the regulation to make it clear that these kinds of transfers are permissible. Moving on, the next one is the committee jurisdiction determination. Under commission regulations, a committee that makes 70% of its contributions or expenditures to support candidates or measures in one city or county becomes a general city or county general purpose committee, and this determines where they file their campaign statements. Based on some advice that we provided to LA Ethics and San Francisco Ethics, we want to clarify that the 70% threshold is based on the expenditures and contributions actually used in support of that candidates or measures, as opposed to their total expenditures for everything, including those things that are unrelated to the actual support of the candidate or measure. So it's just a clarification. It's advice we've already provided. It's just something the staff is proposing adding to a regulation. Moving on, the next one would be 84308 regulations, and this is staff anticipates multiple revisions at the time we adopted the initial packet of regulations for 84308, which is the restriction on officers of an agency accepting contributions from parties or participants in a proceeding before them involving a contract or entitlement. It was a large change in the law. It required everybody that was here, it required extensive regulations, and we were just looking to fill in those things that we may have missed over. The one off the top of my head is competitive bargain for competitive bidding situations. We said it had to go to the lowest bidder, but when you're selling something, it needs to go to the highest bidder. So we just did an advice letter saying, yes, the highest bid, like we defined it as the lowest bidder, but in that situation where where the agency is selling something, competitive bidding means going to the highest bidder. So we need to correct those little mistakes like that. It's just something that was overlooked in the initial packet. Moving on, FPPC audits. The act gives dual kind of authority to the Franchise Tax Board and the FPPC to conduct audits. Most of the requirements for audits specify that these are requirements for the FPPC and the Franchise Tax Board, but there's a few random ones here and there that say it applies to the Franchise Tax Board and does not clearly state that they apply to the FPPC. We've always operated under the presumption that they also apply to us. So this is actually a proposal by the Audits and Assistance Division to make it clear in a regulation that all these audit requirements that apply to the Franchise Tax Board also apply to us. And then there's one additional addition, which is adding language that allows the FPPC to admit candidates that were already subject to an audit by either us or a local agency from an audit draw for, we do random audit draws where we select who's going to be audited. If they've recently been audited by us or a local agency, we want to omit them from the drawing. This was actually in a prior regulation that was the portion of which was codified in a statute, and from all indications, it was just inadvertently not included when it was moved from the regulation to the statute, and it's something that the Audit and Assistance Division is asking that we reinsert through another regulation.
So, sorry, can I ask a clarifying question about that? Are you saying that the statute expressly already provides for us to exclude
No,
those folks from the pool?
This was a provision in a regulation.
Yes.
That a portion of that regulation was moved to a statute, and this was left out.
left out of the statute?
Left out of the statute when it was moved. When the portion of the previous regulation was moved to the statute, this provision was left out of the statute.
Okay, so then that actually gets to the question I was intending to ask, which is, are you satisfied that we have the statutory authority to make that type of exclusion and provide for that by regulation?
I think so. I mean, we have the authority to fill in the blanks, and right now there's required drawings, and this is a reasonable to effectuate the purpose of those drawings. This is a reasonable position to take in who to include in those drawings. So we are comfortable that we have the authority to go through with this.
Okay, all right, thank you.
The next one is a conflict of interest, public generally exception revision. The act allows officials to participate in a decision despite a conflict of interest if the effect on their financial interest is indistinguishable from the effect on the public generally. That being said, when we compare the effect on the official and the public generally, we tend to look at the entire jurisdiction of that agency geographically. So this overlooks very small, like smaller agencies that have somewhat limited jurisdiction in what they do in managing like an airport or a harbor, because most often their decisions only affect those people that use the airport or harbor. And we're comparing them to the multiple counties could be their jurisdiction, but they technically are only making decisions relating to the people using using the facilities. So this would be an expansion of the public generally exception that allows an official to participate in a decision as long as the decision affects all the users of that facilities in the same way it affects the official as a user of that facility. And the other problem is that most often a lot of these officials that sit on these kind of boards are users of the facilities. That's what gave them the interest in joining the board to begin with. So this is actually a fairly common problem that is something we're trying to provide some relief for through through a revision to the existing public generally exception. The next one is related to carryover contribution, and this extends some of the work we've been doing over the last year as far as, but this one, current regulations state, so under the Act, a candidate may carry over a contribution raised in connection to the election to pay a campaign expenditure to a subsequent election to the same office. The current regulation, adopted in 2002 after considerable debate, defines subsequent election for same office as the election to the next term immediately following the current term, or for a special general election immediately following the primary or special primary election for the same office. As requested by the Commission, staff will be providing a summary of the prior history of the adoption of this regulation so that the Commission can determine whether to further explore the definition of subsequent election for these purposes.
I do on this one.
Question, okay.
Thank you. So I'm glad to see that's here. That'll be our opportunity perhaps to have a conversation about the public comment letter that was submitted. I think we heard about it in October, but it was submitted back in August on this issue. When that time comes, my understanding, we're also going to be covering, it doesn't say that here, but we're also going to be covering when a candidate, well, something that we had pre-notice for already, and it's when a candidate wins the primary and is done. Let's say they're a supervisor, a district attorney, a county level. What can they do with funds? Can you just confirm that in January we'll be covering that in addition, because it's kind of within the same regulation?
My understanding is, yes, we will be looking at not only that, but also the withdrawing from the primary prior to the general situation that we've been discussing. Those will be included within this somehow. I'm not quite sure how they're.
Because we had pre-notice of that.
Right, that's been pre-noticed, and it will come, and it is anticipated that it will come back up for adoption at the same time that this comes back up.
Well, hang on a second. Because I know you're sitting in for Mr. Bainbridge. And so Commissioner Baker, stepping all the way back for the benefit of Commissioner Ortiz in particular. And so earlier this year, staff brought us a regulatory proposal that would have done two different things. The first would have resolved what we think is a conflict between the Brown advice letter and the Kaufman advice letter with respect to transferring money. The second issue was the one that Commissioner Baker just identified, which is when you win outright in the primary, what do you do with money you have raised for a general that you now don't have to run in anymore? And the statute doesn't directly address that situation. It involves the same statute, though, that contains the subsequent election language. And so we received a public comment letter asking us essentially to reconsider and verify that the current language in our regulation on subsequent election is consistent with the statute. So it's now a third issue related to a series of statutes that we were already looking at for a different purpose. And so in light of that, we had an interested persons meeting in October instead of proceeding right to adoption on the first two issues because we wanted to get additional stakeholder input. Secondly, we directed staff last month to come back to us in January with fuller information about what the debate was, what the decision points were with respect to the current regulation on subsequent election, including understanding what proposals were considered, why they were rejected, why this particular language was favored by the commission at that time. Because it all deals with the same statute and the same regulation, I don't want to lock us into coming back for adoption on the first two issues if we decide on the third new issue that we want staff to do additional work because they'd be amending a regulation and then coming back a few months later with another amendment to it. It makes sense to do that regulation package all at one time. And so while information's being presented in January, we had not, in my conversations with Mr. Bainbridge, anticipated that we would agendize that decision point for adoption on the first two issues in January. So
I did not mean
that makes sense.
I did not mean to suggest we were coming back in January with an adoption of those two issue points, only that is my understanding that those two issue points will be included in going forward in this as either a package of all three issues or a package of the first two issues, depending on the determination on this third issue. You're right, it's not in here, and I actually wanted to confirm with General Counsel, but he was not available, why it was not included actually in this calendar, but my understanding that they will be moving forward somewhat as a package. And
Thank you for the clarification, and I can't help myself. You know, when people aren't in the room, that's when you give more work to do, from my experience on anything I've done. But in seriousness, thank you for clarifying that point. I understand those first two issues will not necessarily come back for adoption, but they will be part of the conversation. And I was not at the meeting last month where the subsequent election part of this conversation, which you've identified as a third issue, was requested. So I'll just give a little heads up on that. The public comment letter that we received on that had many citations and requests about our regulatory history. I don't even know if they cited, they just said it. When we do that, I'll be very interested in addressing those. It doesn't have to be a back and forth on every point, but that's our opportunity. And since it was a public comment that brought this forward, I think that'll be helpful to have. They may not be correct, I don't know, but that's my heads up on what I hope will include both the regulatory and legislative history on that. And that's all I'm going to say on that one.
Thank you, Commissioner Baker.
that moves us right into the last one on the list, which is paid social media post. This is a result of Senate Bill 678, which is effective at the first of next year, which requires a disclaimer on content posted on a website, web application, or digital application by any person paid by committee in connection with the post. This is similar to an existing regulation that requires third parties paid by a committee to post on social media to include a tag or link to the committee account that provides the committee's disclosure. So this is resulting from the bill. We were looking at repealing the existing regulation to harmonize the new law with whatever the regulatory guidance is. So that's why this one is necessary and why we're proposing it. With that, I could mention that this has already generated some comments from San Francisco Ethics, and they presented some ideas that we haven't had a chance to fully examine yet to just determine whether or not they'd be appropriate to include. They will all be reviewed and looked at and researched prior to the January memo, and whether or not we'll include them as proposals for the following year. And then in Law and Policy Committee last week, there was a discussion of additional proposal to cover cryptocurrency. Two issues. One is how how to report them on a SCI, on your statement of economic interest, your Form 700, and whether or not they're required to be reported because as an investment or whether or not they're just reported as cash. We've advised that that they're not reported because they're just treated like a cash, like the cash in your pocket. I mean, it's just, you don't report how much the cash is not an investment that would require reporting. And then the other one is how committees who accept a campaign contribution report that contribution on their campaign statements. There's indication that they're reported as in-kind contributions, but that's not necessarily the simplest or easiest way to report them. So we're looking at clarifying how the best way to report them on campaign statements as well. So those are something we anticipate including in the January proposal.
Great. Thank you, Mr. Lau, and good summary of what we talked about at Law and Policy. All right, do other commissioners have additional ideas or comments on what we have so far in terms of our regulatory calendar for next year? Commissioner Wilson?
Not at this time, but at the appropriate time, in our agenda, towards the end, I have an additional idea. I've been so inspired by Mr. Lau's presentation that I came up with another idea for consideration.
All right. Thank you, Commissioner Wilson. Yes, I know, right? You sure you don't want to tell us now? You sure? All right. All right. Any other commissioner comments on this iteration of our regulatory proposal for next year? All right. Any public comment on item 9? These are our possible regulation projects for next year. Hearing and seeing none, we will go ahead and proceed to our next item. Thank you, Mr. Lau. And we have a lunch break scheduled at 12:30. The next item is a presentation on some pre-notice amendments. I suspect that's going to take longer than 20 minutes. Hope springs eternal, I know, but it's going to take longer than 20 minutes. So I'm going to hold item 10, and let's proceed to item 11, our legislative update, which I think dovetails nicely anyway from our regulatory calendar. And with us is our senior FPPC Legislative Counsel, Ms. Nakano. Good morning.
Good morning, or looks like we're at afternoon. Good to see you all. Lindsay Nakano, FPPC Senior Legislative Counsel. Today I'm presenting 7 ideas for potential commission-sponsored legislation. Some of these ideas are ones that the commission has pursued in past years, and others are new ideas from commission staff. The purpose of my presentation today is to brief the commission on these proposals, get your thoughts and questions, and as alluded to earlier, to get any additional ideas. Also, ultimately, to get the commission's direction on which proposals to pursue at the end of the presentation. The first idea relates to lobbying audits, which of course has been on the commission's radar for a number of years. For some background, the Political Reform Act includes audit provisions that, in part, require the Franchise Tax Board to audit 25% of all lobbying firms and lobbyist employers every 2 years, which comes out to about 300 audits every 2 years. Due to insufficient resources, FTB has been unable to complete most of the required audits, with no audits completed for the years 2017 and 18, and 4 completed for years 2019 and 2020. The bill would transfer the lobbying audit duty in the PRA from FTB to the commission. There would, of course, be a significant workload impact, and the commission would need 9 new positions in the audit division. The second idea relates to placement agents. Placement agents are, very generally speaking, individuals who sell investments to public retirement systems like CalPERS and CalSTRS. In 2010, the legislature redefined lobbyist to include placement agents, so these individuals are subject to the same registration and reporting requirements and restrictions as traditional lobbyists. Placement agent activity is by nature very different than traditional lobbying activity. They lobby a very limited number of agencies. Their activity is typically low and for a short period of time in the state. So staff think it makes sense to better tailor their registration, reporting, and training requirements to their activity. The third idea relates to local ethics training. State law requires local agency officials to take an ethics training course that includes ethics requirements in the PRA. After this requirement was passed in 2005, the Commission opted to voluntarily create a free online training course in consultation with the Attorney General's office that satisfies those training requirements. The Commission has continued to offer that training as a free service. It's a very beneficial service. Staff would like to continue to offer it, but the system is old and in need of an upgrade. We also do not have funding for staff to maintain the system and respond to the hundreds of inquiries received each week from local officials who use that training course. Additionally, recent legislation expanded the number of local officials who are subject to those training requirements by more than 2,000 officials, which kicks off in 2025. The legislation would provide a statutory basis to request that additional funding and to continue to offer this beneficial service. The fourth idea looks to the good work of the Commission-initiated Digital Transparency Task Force. In 2019, the Commission authorized the creation of the task force to examine issues relating to increasing transparency around digital political advertisements. The task force had a diverse membership, including academics, political consultants and practitioners, representatives from good government groups, online platforms, and other jurisdictions. Their work culminated into a final report that included policy recommendations. The bill would effectuate one of those recommendations by authorizing the commission of a study to examine whether there are different kinds of disclaimers on digital campaign advertisements that would more effectively inform voters about who is paying for these ads. This would result in data that could help shape recommendations for best practices and potential future legislation. The fifth idea is new this year. It came from Senior Counsel Kevin Cornwall in the Legal Division. It relates to the conflict of interest provisions, and in particular, what counts as income for those purposes. For background, the Political Reform Act exempts from the definition of income salary and other benefit payments received from a state, local, or federal government agency. This exemption does not include salary from a Native American tribal government employer. This results in uneven treatment under the conflict of interest provisions, depending on the type of government salary received, even for similar positions. The proposal would amend the definition of income in the Act to exempt salary and other benefits received from a Native American tribal government employer for employment in a Native American tribal government position, in the same way that salary and other benefits are exempt when paid by local, state, or federal government employers. For example, a person employed by a Native American tribal government who is also a city council member would have to count their Native American tribal government salary and benefits as income for purposes of determining whether they might have a conflict relating to a decision of the city council. In contrast, another city council member employed by any other local, state, or federal government agency, even if they had a similar position to the person employed by the tribal government, would not count their government salary and benefits as income for those same purposes. Additionally, under Section 1090, which generally regulates conflicts in the context of government contracts, the phrase government entity is not defined to be limited to local, state, or federal government agencies, and is thus interpreted broadly by the Commission to include Native American tribal governments. This proposal would therefore also help to harmonize the conflict of interest analysis in the Act with the Section 1090 analysis. We are still in the process of engaging appropriate stakeholders, and I will keep the Commission updated on any feedback we receive. The sixth idea relates to waiver of the late filing fee and came to us via the Commission's Statements of Economic Interest Unit. For background, the Political Reform Act permits filing officers to waive the daily fee for late filed reports or statements under certain circumstances, but that waiver is limited to a set number of days from the date the filing was due. This proposal would add authority for filing officers to waive the late filing fee beyond the time limits in the Act under additional specified circumstances. And I'll give a few examples. The SCI unit has seen situations involving technical errors where there was no significant loss of disclosure. For example, officials are sometimes allowed to submit a single statement that combines two statements, such as the annual and leaving office statements, And when they submit that single statement, the official has to check the box for both annual and assuming office. If they accidentally only check one box, they have technically failed to file the second statement. This proposal would allow the filing officer to waive the late filing fee when that second statement was late because of a technical error like this. Additionally, the SCI unit has highlighted situations where the filing officer had failed to send the original statement or forgot to date stamp it, resulting in a late submission. There are also cases where the filing officer failed to provide the filer's correct email address, so the filer did not receive notifications about when their statement was due. The SCI unit also requested authority to grant a one-time waiver for first-time filers. So these would be individuals who have never before been required to file Form 700 and may have not had sufficient understanding of their filing duties. Seventh is a collection of minor changes and cleanup proposals. Most of these ideas were considered and approved by the Commission for 2023. Today, I'll go over some of the minor substantive changes, including a couple new ideas. First is the proposal that would require redaction of committee bank account numbers on the committee's statements of organization. The purpose of this proposal is to protect committees from financial fraud. This year, the proposal would additionally require redaction of the names of individuals authorized to obtain committee bank account records for those same purposes. We have been contacted by an interested potential author for this particular proposal, and in connection with that potential legislation, we have been asked to consider an additional proposal, and this one does not appear in the report, so I will describe it to you. The additional proposal relates to a situation where a committee is reporting a contribution that it made to another committee. Under existing law, the committee making the contribution must report the street address of the committee that received the contribution. However, since street addresses are redacted on forms online, it's apparently not always easy to get the committee's street address. So the contributor must often email SOS for the PDF copy of the receiving committee's statement of organization, which takes time and takes up resources for SOS. So this proposal would aim to find an alternative to reporting the street address for a recipient committee that is receiving a contribution from another committee. Some options include requiring disclosure of the receiving committee's PO box instead of their street address, or potentially no address would be required. Both the name of the committee and their committee ID are disclosed, so that's arguably sufficient to identify the committee that's receiving the contribution. Because this additional proposal is not in the report, I'll pause here if there are any questions or comments.
All right. Thank you, Ms. Nakano. I have a question, and maybe you can't answer it today, but maybe at the next meeting we can talk more about it. What is the purpose of requiring the committee making the contribution to report the address of the committee receiving the contribution when the committee ID number is already there and the address is already available from the Secretary of State for anybody that wants to access it? Like, what is the purpose of imposing that burden under existing law on the committee making the contribution?
I think under existing law, it's a general requirement, so anytime they make a payment to anyone, a committee or another person, another entity, they're required to report the street address. So for individuals, it might make sense to have that further identification of who they are, where they are. But for committees, I think that justification is much less since they are identified in other ways.
Okay. All right. And this change would be limited to just committees then, right?
Right.
So if it were an
Recipient committees,
individual, then it would be treated differently?
Correct, yes.
Okay.
Yes.
All right. Commissioner Baker.
Thank you. Couple.
Primarily one question on this one, I came back to you. If I remember correctly, PO box is generally sufficient for identifying source of a contribution. Either now or later, can you address why that's the general rule and why by allowing PO boxes in this particular instances, it might be fine, and not against the underlying policies or rationale they have in the Code of General?
Sure. I think generally speaking, the PO boxes are not allowed because it's not an adequate way to be able to find that person and to contact them. In the case of a committee, they have other filings that are available. They have their statement of organization that has their address on it. That's available to the commission. That's available to our investigators, auditors. So there are other ways to identify and find that that committee based on other public documents that are available. So as long as we know their name and their committee ID, being able to find other information about them is pretty readily available.
Thank you.
Commissioner Wood?
So this is going to be similar to my question for the next item, which is, there may be a public benefit to knowing an address for a committee. And you've been talking about the enforcement rationale for transparency, but there may also be an informational rationale for the public. And so I'd like to understand more about when the public has access to that information and when not. If it's something that you already said when it's online, they don't have access to the information, right? So maybe there's nothing that can be done in the context of this particular legislative proposal, but I don't want to focus entirely on the enforcement rationale to the exclusion of the information rationale for having these kind of campaign finance transparency regulations. And so if you have any information on that now, on when the public can actually access that, I would be really eager to hear it. Otherwise, we can just talk about it another time.
Yeah, I can speak on what current law is. So currently on the online copy on CalAccess, addresses are redacted, but the public and anyone can request from SOS the PDF copy, and that is an unredacted copy that includes their street address and additional information on the form.
That is an absurd administrative burden. I know it's not your fault, but that is ridiculous. And I would actually like to pursue that kind of thing in the future because, well, we can, let's get through your next item. And then I want to talk about like the information we can glean from geography, because making researchers or journalists comb through a bunch of PDFs is really delays the public getting information that they might benefit from. I know it's not your fault, Ms. Nakano. I'm sorry. I didn't mean to be so emphatic.
Understood.
All right, thanks, Commissioner Wood. Commissioner Ortiz, and then
Thank you.
Commissioner Wilson.
I want to make a comment, but before that, I want to say that I shared the chair's and Commissioner Baker's concerns in the question that they raised. But my comment is this: I'm very happy that staff is consulting with the appropriate representative from the tribes. That's really to make it inclusive. That's very important. Thank you.
Thanks, Commissioner Ortiz. All right, Commissioner Wilson?
This is kind of a follow-up, Ms. Connell, to Commissioner Wood's comment about, transparency and access to information. To what extent is the public safety issue something that would be addressed in this context?
With regard to this first proposal I spoke of, I think bank account records and the address of the contributor, that's less of the public safety concern. That appears a little bit more in the next sub-proposal, which relates to redacting the street name and number on forms that are provided to the public.
Yeah, that's where I'm more concerned about the street number, and all of a sudden someone shows up at your house because they're concerned about how you handle something administratively. But okay, thank you.
All right. Any other questions on the new potential addition to the redaction of bank account information proposal? Hearing none, go ahead and continue, Mr. Kano. Thanks.
Okay, moving on to the next minor change proposal. It does relate to the redaction of street names and building numbers on campaign reports and statements before those are made public. So I think, as we've heard, there are reasons on both sides why it can be beneficial to have those street addresses available to the public, both for purposes of a committee that is trying to find that address to report it, or in the case of academics who are doing research and that location information is important. So I think we tried to balance that by requiring that only the street name and building number be redacted. So the zip code and the state, of course, would still be available, providing general region information about the individuals who are reported on these statements and reports. So that's kind of the balance that we tried to strike between protecting security and privacy issues as well as providing that important public information.
just to clarify, so the city name would not be redacted. It's, what it says here is.
That's right.
Redact the street names and numbers, but the city would still be available,
Yes,
right?
city, zip, and state.
Okay, thanks.
Well, I'm trying to channel Commissioner Wood. Like a city could be Los Angeles, or it could be Dublin, California. So as you go through this process, having already heard the comments from Commissioner Wood, and now I'm piling on, because we really haven't had that level, that type of commentary at the Law and Policy Committee. This will just be the input that you got to be thinking of big cities and small cities. It makes a difference if it's just the city. I realize the zip code is going to be helpful. If there's any other ways to reach that balance, I'll be looking forward to those ideas. Thank you.
All right, and Commissioner Wood had her hand up. Commissioner Wood?
Thank you. I guess I have two questions. So the first is what your source is for public officials being subject to increased threats and what time frame you're thinking of. Because putting that kind of a statement in a public document that could later be used in a court case to try to establish a fact that would then work for campaign finance deregulation is I would like to know the source of that. And then the second is if you can just remind me whose campaign statements would be subject to this. Like at what levels of government are we talking about?
I think, so the way that we've defined it, to answer your second question first, these would be all of the campaign statements and reports that are reported under the Political Reform Act. So, yeah, so that would cover
State and local.
State and local, that's correct. For your first question, I think this is something that we've heard from the legislature generally, and it's something that they've pursued in other legislative forums or have tried to. So I think that's a good point and something to look into more and be diligent about when we speak about it. So I appreciate that comment and we'll consider that moving forward.
Just one additional thing. Thank you for those comments. So, you know, the city and zip code will not get you to a school district, right? It won't tell you about the types of neighborhoods that are represented among the contributor base to somebody who's elected, right? So our elections are often tied to geography. Sometimes you know, a city doesn't have districts or whatever, but like in general, when we have more fine-grained information about who the donor base is, we're able to better predict who will, like how the people will vote, right? Or how the elected representatives will vote. And so because this also includes local filing officers, you know, I can just imagine even in the city where I live that I would need to know neighborhoods at a minimum, right? Census tracts, something like that. And so we're obscuring a lot of information that would be hurting local voters who need to be informed about who they're voting for school board, for city council, and things like that. Thank you. We can talk more offline about it anytime you want. I really care about this stuff.
Commissioner Wilson?
I'm not sure I care about it that much, but I do have a comment to add. I think Commissioner Wood, touched on it, but perhaps, she talked about census tracts, maybe a major intersection. If you're, to go back to Commissioner Baker's reference to Dublin versus Los Angeles, you might be able to drive all over Dublin and eventually find what you're looking for, but not in Los Angeles. So maybe census tracts or the, major intersection within a half a mile of the actual address might be another way. So I'll leave that to the experts. Thank you.
Thank you.
I affirm that characterization of both Dublin and Los Angeles.
Commissioner Wood, I'm actually curious about your comments because I feel like the tension that's emerging in this discussion is as between an assertion of a need to create greater privacy protection for elected officials and Ms. Nakano will get us more concrete data points on that. I think that's a good point that you made. On the other hand, the public's need to know, and particularly here, I suppose that need really, for putting a fine point on it, is having immediate access online, because I mean, today it's redacted online, right? And so here, they couldn't get it at all. They couldn't request a paper copy and then get that information. So from a voter's standpoint, knowing the precise address of a public official, why is that necessary, as opposed to something like the official lives in this particular district, let's say, like if they're in Assembly District 1 or Senate District 2, that type of information. Why does it need to be so granular as to be their precise home address?
Yeah, it's well phrased. So, everybody on the school board where I'm at lives in the same Senate district, I assume, right? Because I'm in a smaller town. But they all have different kind of home schools. And so I might not want 5 members all from the same kind of home school, like the school they're districted for. You see what I'm saying? And so the address, the number and the street name would help me get that information. But also something like the census tract would get me very close to that information. We also know that there's a bunch of historical reasons, including redlining, right, that mean that our neighborhoods are composed differently in terms of race and in terms of class. And depending on how the districts are set up, one district may be really white and one district may be really black, and then one may be really, really diverse. And so you may want to know where in the districts that these people are from, because it's, it might match some value that you hold as to representation and who has a seat at the table. And so if we obscure a lot of geography information, we obscure information about, who may have a seat at the table, who may have the representative's ear, who may be getting more attention in terms of, resources and oversight and things like that. And so to me, I think there's probably a pretty big loss of information. And I'd be happy to look at the academic research on this as well. But I have a question about the first thing you said, which is, because I haven't actually tried to do this in California. So already, if I donate, my information's obscured. It just says my town and my zip code, basically. That's a question. I know I said it like a sentence.
On the online copy?
Sure.
I can't recall how much of the street or the address is redacted currently on the online copy.
Hang on, Commissioner Wood. We're looking into it.
That's fine. I'll just fill the time by saying that it's possible that there has been an increase in threats. That's possible to me. We do know that there's almost no evidence of harassment of donors. There's almost no evidence of it. You got to think about the probably hundreds of millions of actual donations that are made in this country in every election cycle, and how little threat that donors are subject to. And so hiding information from the public, or obscuring it, I will say, from the public, or making them jump through extra hoops and get PDFs and then transfer that to a computer and all that, it may be depriving the public of a benefit where the actual cost in terms of risk of harassment is actually quite low. And so there's a really great amicus brief about this done by a bunch of political scientists who went and tried to find, all examples of harassment, and it was so minimal. I wish I could give you the actual number right now, but it was very, very minimal. And so you would need a very big risk of increased threat to convince me that losing this information is worth it.
Yeah. All right. Although, to be fair, at least I would be interested in knowing what data suggests that voters actually rely on it for the reasons you point out, which are all great reasons. But in like practical voting behavior, how many voters go look up their members' specific addresses and make decisions based on that? I don't know. Like, I'm just curious, because you have to have kind of both data sets, I think.
Yeah. So I will just say that I've always paid attention to this, right? But I haven't done a study. We do know that voters penalize out-of-state donors, candidates who are supported by out-of-state donors. So there's a geographic tie already. But if you talk to people around who are involved in, local politics, even if they're not running for office, they know who supports the candidates and where they are, right? Especially for something like school board that's really geographically tied. And so, we talk in academia about informational intermediaries, right? The voters themselves aren't going to Cal Access. They don't know Cal Access exists, but the journalists do, the academics do. And so we serve as informational intermediaries to the voters on that sort of thing, But you're right that the voters don't go directly there. We know that.
All right. Thank you.
What did we learn, Ms. Nakano? Anything?
No, this is great. Ms. Nakano.
Yes, I got an update from our very diligent staff. So when the campaign statements are pulled from online, you get the street name and building number, they redact the street name, building number, and bank account number from the online copy. So you're still able to see city, state, and zip.
And that's for the candidate.
That's
and then
for
I assume the same must be true for donors.
any person or entity that's on the statement.
All right. Commissioner Baker has been waiting patiently. So
I can wait patiently even longer, if you can believe it.
Commissioner Wood, are you good if we go to Commissioner Baker real quick?
I would love to, Commissioner Baker.
I'm in no rush. Actually, I did want to, I really appreciate this discussion and Commissioner Wood's good points on it. The point about knowing that voters care if out-of-state contributions, it's also a point in campaigns about, this person's got most of their money from out of the district. I mean, that's an additional area that gets much more local. I appreciate also the intermediary and journalists. We're talking about, do voters really use this information? Well, sometimes they're not digging around, but the transparency is part of our electoral system, and our democracy is also free journalism that can get information. So I want to make sure we do that. On the counterbalancing side, it really is, I don't know if there's increase to elected officials getting, threats. As we talked about when we had the prior bill last year, last legislative cycle related to security expenses for campaigns and otherwise, I've mentioned this before, our address was put on a target list. Please go here. It had to do with gun control. Security measures had to be taken. That was litigated. It's for real. It really happens. And we do see so much about the tenor of things. So I don't know if there's an increase in it. I don't think that would have to persuade me to be sensitive to the safety of our officials. And finally, saying that, there's lots of other ways to find their address outside of what these points are. Sometimes you can just Google them, and that's where the address comes from. So we're having a very good conversation about this. I look forward to Senior Counsel Nakano just perfectly wrapping it all in a bow and bringing it to us as the goal. But we have to recognize the limitations of what we are able to cover, which is not going to be the entire digital world.
Thank you, Commissioner Baker. Any other Commissioner comments on this aspect of what we had titled minor changes and cleanup proposals? All right, go ahead, Ms. Nakano.
All right, and we're eating into our lunch hour here, but I'll continue on. So next is, and this is 70 on page 6 of the report. It's a proposal that also came from our Statements of Economic Interest unit that would address a minor reporting period inconsistency for assuming office statements of economic interests. And I'll note at the top that this is a very zoomed-in, nuanced proposal, so please bear with me as I try to explain the detail. For background, there are 3 types of SCIs or Form 700s: assuming office, annual, and leaving office. In the statute for assuming office statements, it specifies the time periods for which different economic interests must be reported. So real property and investments must be reported if they are held on the date of assuming office, whereas income must be reported if it was received, quote, during the 12 months before assuming office. So under plain language, before assuming office wouldn't include the actual date of assuming office. So for example, if today was the date that I assumed office, I would have to report real property and investments that I own as of today. But if I received a gift today, I would not have to report that on my assuming office statement. The proposal would reconcile the language for the reporting periods by shifting the reporting period for income by 1 day or adding 1 day to the reporting period so that it covers the date of assuming office as well as the 12 months prior. The Law and Policy Committee asked me to look into the legislative history to try to find out if the reporting period inconsistency was intentional or not. The original section in the 1974 initiative did not specify any reporting periods. It actually only required disclosure of real property and investments. The section, as we mostly know it today, was amended by the legislature in 1989, and that's when the language was added requiring income to be reported if it was received in the 12 months before assuming office. I have not yet been able to find evidence of legislative intent on this language, but there is some language elsewhere in the statute that could be read to create ambiguity as to what is intended, as to what the intended reporting period is or was for income. I had mentioned earlier that in some cases, officials are allowed to submit a single combined assuming office and annual statement. In the language for those combined statements, it states, quote, the period covered for reporting income shall begin 12 months prior to the date the person assumed office. So this language only specifies the beginning of the reporting period. It's technically silent as to the end date of the reporting period. So I believe the periods covered for income for both regular assuming office statements and these combined statements should be the same. So I think there's some ambiguity regarding the intended end date for income reported. Arguably, the 12 months language was intended to provide a look-back period for reporting and does not necessarily tell us when the reporting period should end. So additionally, having 2 different reporting periods within a single statement, even just by 1 day, can be confusing and I think would be unusual under the Act in other places. So I'll pause here for any questions on this one.
Any questions for Mr. Cano? Hearing and seeing none, please continue.
Okay, last for this one, it's 7E on page 7. There are 3 minor changes to section 84616. This relates to the requirement that local agencies must post all of the paper campaign filings they receive on their website. These ideas came from Suki Brar, Assistant Chief Counsel in the Legal Division, and they all came up in the advice context. That is, local agencies contacted the Commission for advice because the section either wasn't clear or simply didn't provide any guidance. So these proposals provide clear direction to local agencies on what their duties are in these specific circumstances. I also wanted to give an update on the Commission's potential 2-year bills. We have confirmation that Assemblymember Valencia's office will continue to carry AB 1170, requiring electronic filing for Form 700s next year for those individuals for whom the Commission is the filing officer. And Assemblymember Wilson has also indicated continued interest in carrying AB 868 relating to the Data Act, which would create a publicly accessible record of campaign advertisements that appear on online platforms. And we are beginning to have conversations about the best way to move that bill forward. That concludes my presentation. Happy to take any other questions.
Thank you, Ms. Nakano. For the benefit of the other commissioners, the Law and Policy Committee did meet and are recommending approval of this slate of bills for next year. Of course, if we have additional ideas today that we want to talk about, now would be the time. So, Commissioner Baker.
Thank you. I know we had as I said, inspired idea from our good colleague, Commissioner Wilson, regarding how to deal with lobbying at local redistricting commissions, whether it's a bill that just requires them to register or to give us the authority or whatever it is. I think that's great. I didn't add this feedback at law and policy, I will now, and my colleagues will recognize it, that in the course of visiting with authors and negotiating and drafting these, that a high priority be placed on having bipartisan co-authors, and that the principal office authors hear that from us, that we really mean it, and we hope they will go to all appropriate and extraordinary measures to get them, because that is good for us. I wanted to go back to the measure on income for tribal government employees. This is a little bit for the benefit of our colleagues, but we had some extensive discussion at Law and Policy about how we want to make sure we do this in a way that brings equity, but also doesn't create a loophole. Because many tribal governments have, of course, the traditional government role, perhaps we'd call it a city council or city manager, they have those, but they also own gas stations and outlets and stores that technically may be a paycheck from the tribal government. So there'll be a challenge for us to be sure to navigate that well, to bring equity without creating a inequity or another loophole, treating things differently. And I also just want to say how very high priority the audits bill is. And that, we don't necessarily say, here, we care more about this one, but I'm about to say that. Because, we've seen today and in other measures just how some really egregious violations of our rules and ethics in this state are found only by audit. We have numerous examples, and there were significant special informational hearings last year led by Senator Glazer to bring light to this. And the statistic that, no audits were completed for 2017 and 2018 and only 4 in 2019, 2020. We're going into 2024. We don't know what we're missing. And so that's my feedback. Thank you.
Commissioner Baker, thank you very much. The only thing I guess I would add to that, just going back to the definition of income, I just want to, for our benefit of our colleagues, we're not writing on a blank slate. Your concern is a valid one. Government Code 1090 already excludes the type of income that I think we are laser focused on here, which is truly income derived from service in a government function or a government entity of the tribal government, not a private, for lack of a better term, a private type commercial activity that may have some ownership interest by the tribal government. So tying it to 1090, I think, which is what we're intending to do, does address that concern. Commissioner Ortiz?
Yeah. You were talking to auditors, reminded me. In the transferring of audits to the FPPC, you will require 9 new staff members. Is the transfer and the need to have the staff members part of the same proposal? If so, FPPC will be asking for budget from the legislature to finance these 9? I mean, what comes first, the chicken or the egg? Transferring and the need for additional staff?
Yes, good question. So the legislation would come first, the authority would be passed over to the commission, and then following the passage of the bill, the commission would would submit a budget change proposal for those 9 positions, and then it would go through that budget process.
So if you don't get the money, the funding for that, because the state is some big deficit in the budget, what happens then to the new authority? Because you're going to be shortchanged.
Right.
Hello, Cleveland West Executive Director. So generally, when it goes through the legislative process, then the money has already been tentatively approved as it goes through the appropriations process. So if we do end up with a mandate that we can't fulfill because we didn't get the funding, then we will continually apply for funding at each opportunity until eventually the state is in a position to fund the mandate that they put on us.
So you will acquire this new authority, perhaps without staff. That's complicated.
Yeah, unfortunately, that's the way legislation works, but they hopefully have considered it all as they go through the appropriations process to make sure that the budget can fund it.
Good. Okay, thank you.
Commissioner Wilson?
Thank you for your presentation, Legislative Council Nakano. I would defer to you and Council Lau on this idea, whether would require legislation or it could be done through regulation. But with close to 500 cities in California and other local entities, if you try to find an SCI for a particular individual, you might go to San Francisco's ethics website and have easy access. But many jurisdictions don't make it easy to find an SCI. That's something that is kind of, common knowledge. So what type of action would be required if we wanted to require or direct all local governments, special districts, to upload or make accessible via a link SCIs that come within the purview of their jurisdiction? I mean, if we can track who hasn't filed an SCI in a timely manner, once that process is completed, there should be a way to be able to say, okay, I want to go to city X and be able to see if an SCI was filed for a particular, individual. I know that we have a model right here through our SCI unit. If you're looking for a legislator or legislative staff's SCI, it's easily accessible. So just something to consider, down the road. If we're going to require filing deadlines and other information, it should be readily available to the public.
So are you kind of enticing us to amend this legislative proposal to include a requirement that local governments and other entities that receive SEIs make those public available for their website, for example?
I mean, I necessarily want to go that far because I don't know how it would impact the current process that you're going through, but I think it's something that we should definitely look at, and to the extent it's feasible to incorporate it into some of these, since they are minor changes and cleanup proposals, perhaps this could be addressed, through that mechanism. But, when you look at 84616 reference as it relates to certain reports, it would only make sense that you be able to access SCIs in online in a way that, is easily accessible to the public.
Thank you. That's something that we can, I think, brainstorm and talk more about and maybe come back with some ideas of how to make that more accessible.
Yes, thank you, and, thank the chair for his suggestion. I just don't want it to impact anything that's, currently, in the process in terms of, bill introduction deadlines and so forth.
Yeah. Thanks, Commissioner Wilson. Do any other commissioners object to Ms. Nakano conceptualizing what Commissioner Wilson just described and talking to some authors about perhaps adding that to one of our proposals? All right, then I absolutely I agree. I think it's a great idea. So, Ms. Nakano, can you add that to your ongoing list of things to do, please?
Okay, thank you.
All right. Any other additional ideas, concepts we want to explore? Commissioner Baker?
No, I just want to, if it's, maybe I'll let you do the motion. I was going to move to adopt this legislative package with the feedback that we've provided to include the local redistricting commission lobbying disclosure topic. That's my motion.
Yes. I second that motion. Is there any public comment on this item? Hearing and seeing none. Ms. Contreras.
Commissioner Baker?
Aye.
Commissioner Ortiz?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
I'm actually going to abstain.
Chair Matich?
Aye.
The motion passes.
All right, very good. Thank you, everyone. Thank you, Ms. Nakano. It's going to be a busy year.
Thank you.
All right, let's go ahead and adjourn now for lunch and come back at 1:25. Thank you. All right, let's go ahead and reconvene following our lunch break. We are on item 10, pre-notice discussion of proposed amendments to the commission's warning letter, prep, and streamline programs. And with us is our Executive Director, Galena West, and Assistant Enforcement Chief, Chris Burton. Good afternoon.
Good afternoon.
Hello. So we're going to have a PowerPoint presentation, possibly. It's going to come up on the screen at some point. I heard a O, so I think we're all on the same page now. All right, here we go. Okay. I noticed there's some sort of delay in the video, so I apologize to people having to watch this and have my lips go without the words. I know that drives me crazy on TV, so good luck. Okay, so basically what Chris and I are presenting today is about every couple years, the commission takes a look at the streamline programs and gives them an overview or refresh based on the comments mostly from the enforcement division. Things that are working, things that aren't working, and any comments from people from the outside that have been subjected to them or have gotten to participate in them, depending on their point of view. So what I wanted to do is give a little brief history of how we got to where we are today, and then go through the changes for you.
And can we just for Commissioner Ortiz in particular, her benefit, so streamline is an alternative enforcement mechanism separate from mainline. Can you give us like just a brief overview?
Yeah, that's my next slide. Yes. So our clicker's not working, so we're going to be clicking to the next slide, which is that. But basically, okay, what the next slide says is back in 1999, the commission started noticing an increase in complaints and cases. And with that were some private attorney general actions that were also being taken about major donor filers. So they're pretty easy kind of cases to look at because you look at the recipient committee's campaign statement, you identify people that qualify as major donors, you check if they filed, and if they didn't, you file a civil action. The commission then has 120 days to take an action. And if we don't, then they can proceed with their civil action and keep half of the amount not reported, which is what the judgment would be. So it was actually a blessing in disguise because it helped the commission to identify a streamlined way to handle cases that were of the more minor violations with lower public harm. And so that's where Streamline was born. So we also extended that at the time to late expenditure reports. So there you go. There's the basics, late contribution reports and expenditure reports and major donors, the start of it all. So in 2015, we decided to present it to the commission as a full-fledged program and add some of the other violations that we thought would be ripe to handle in a more expedited version of a stipulation. And that way we could handle those quickly, have enforcement focus on the more egregious, serious, intentional violations, which is the path that we move forward from 2015. Hold on. So we reviewed in 2018, then we added 9 additional types of violations that over the years enforcement had talked to the commission about during commission meetings saying, hey, this is a mainline stipulation. This is something that we could definitely have handled through a more expedited process. Commission agreed, so we added those. And then in 2020, we did another revisit, added 2 additional violations, and then applied all those. So we're doing the same type of review here. And this is in response to the enforcement directives. So the enforcement directive said, hey, enforcement, we want you to reach these goals. We also want you to look at prep and streamline as a way to help you reach these goals because we really want you to focus on the more egregious intentional violations. So as you'll be reminded quite a few times through this presentation, then the more egregious intentional violations, fraudulent activity, all of those things are not included in Streamline. So there's none of those, all of the things that you saw on the agenda today, not things that would be in Streamline. Okay? So moving along.
Go ahead. So these are the big changes. All of the little tiny stuff we didn't really highlight because there's, wording and other little things that we didn't want to talk about. But the biggest change is we've reformatted the regulations. So as you can see, as we've done this over the years, we had Tier 1, which is for the very minor violations. Then we added Tier 2 years later. And so it went Tier 1 in 18360.1, penalties in 18360.2, Tier 2 in 186.3. So if you had one violation, you would have to have it look into point 1 to see if it qualified for Tier 1 or a warning letter. And then you'd have to jump to point 3, look up the violation in that regulation, see if it qualified for Tier 2, and then you have to jump back to point 2 to figure out what the penalty would be. So now what we've done is we've batched it to where you can have a violation where you look at it in either point 1 or point 2, they're by subject area, campaign and ethics violations. And you can go from, does it qualify for a warning letter? Does it qualify for prep? Does it qualify for Tier 1? Does it qualify for Tier 2? And you're going through the whole process in one spot to figure out what applies to this case with these factors. And then you can look at the penalty section in point 3. So try to simplify it, make it easier to apply, and to be able to, when you put things together like that, you also see where you're going, this is duplicative. I can take this section out. This is redundant. So it was a nice thing to do. I think it's going to read a lot easier for people trying to apply it. The other thing we did was we took a look at the population thresholds. So the review a couple years ago, we had reduced them. So what a population threshold does is it says, if you have this many people in your jurisdiction, your limit for applying Tier 1 and getting this penalty is, say, $16,700. And if you have this population, your limit's $32,400. And it was just very specific. So what we've found as we've applied that, it's not only onerous to apply because you're constantly looking at a population chart in order to figure out what applies for the limits for if it's Tier 1, Tier 2, all of that. But also the smaller jurisdictions were getting a little less inclusion into the streamline programs, which a lot of the smaller campaigns are what we're trying to include in the streamline programs. So with that evaluation, we decided that a state local standard would make more sense, where we say locals have this standard and then anybody above 1 million in population will also fall into the state standard. So the bigger local populations and the state in one, everybody under 1 million local in the other. Okay? So that's that one. Okay. Sure. On that one, so does that mean, for example, if you're a state assembly member, which is generally, 600,000 people, that's under 1 million, so that would be considered local and would more likely qualify therefore for Tier 1? Or that just sets a domino effect on which tier and which penalty amounts?
That's exactly right. So it would be under 1 million, so it would be considered into the smaller population groups, because almost all of the assemblies are around 550,000.
And then for a state senator who, is across the building and does, they may not think this, but they do about the same work as a Assembly member. They're working on bills, and in the legislature, they have about 1 million constituents, a little bit more. They, just because of that, they would be subject to a different set of rules, or not rules, but thresholds, okay.
So about half of the senators are over 1 million and about half are under. So the jurisdictions that are under would be considered with the lower thresholds. And then when you have more people that you're reaching and you're spending more money, you would have a higher threshold, yes.
Is the difference really very big between the ones that are below 1 million and above? And I'm asking because, the redistricting is about, the populations need to be about equal within a very small differential. It's supposed to be kind of de minimis.
No, I have the 2020 census information, and it ranges from about 930 to 1 million
maybe 100,000. So it's enough of a change to make you go, oh, yeah, that's bigger, that's substantially bigger. But yeah, I mean, you could have one that's 999, and one that's a million one, and they get two thresholds. But that's with any bright line rule that you're going to set. So any of the thresholds currently in place had that same issue.
But it was dollar driven. No, it was
the same. It was population driven.
Yeah. Okay, gotcha.
Yeah. So the current thresholds were the same way. So the assembly was also broken up into two different categories under the current rules, as well as the Senate.
Thank you.
So, to understand this system,
I have an example that I am going to show.
so a tier 1 or tier 2 committee or person or whatever, it's not based on the violation, it's based on population.
So close. So what it is it's based on both. So we take all of the violations and we put them in separate sections. So right now we're talking about campaign reporting. And campaign reporting, based on whether or not you meet the threshold of 25,000 or 50,000, let's say, for an example for campaign reporting, would depend on the population. And that's what the current rule is, and that's what this rule is.
So streamlining meaning you're becoming efficient in your
right.
How do you process? So the first step is you figure out what the violation is going to be like, what the kind of the sphere, kind of the thing, and then you look at the population. And so, for example, what Commissioner Baker was talking, the difference between, even within Senate, how you deal with that. How you're expediting that? You're still going to have to do the evaluation of the violation.
I understand. Okay, so let me take a step back. So the reason that this works so well is because what it is a form. And I can't share my screen, but if you look in the executive staff report, there's forms that are filled out that are cases. And it is an expedited way to evaluate the case in order to get a more formulaic penalty. And that's what expedites it. So the analysis is the same, whether you're doing a mainline or a streamline. You still have to look at all of the factors. And then once you identify that it's a violation that's included in streamline, then you go through the factors in streamline, and then you fill out a form. And the form is what is then on the agenda, because that's the settlement that you've reached, as opposed to the main lines that you saw today, where it's the story and it's the full exhibits.
Thank you.
Okay. I will have examples on this population. Okay. Okay, so the other big changes we added when you qualify for PrEP, and in the memo I refer to, almost all of these are going to qualify for PrEP. There's certain ones that won't, like slate mailer organization. We're not going to have a PrEP program for slate mailer organizations. That's a business, and it's not really got a lot of requirements that we could form a training over, and no other training is appropriate. And then this way, the commission's already seeing what the qualifications for PrEP would be for each program. So this gives staff the freedom to then move forward and produce those trainings and get them out and started as soon as possible. Then we removed the settlement amounts to certain times in the process. So now the commission or the staff will have the opportunity to be able to look at the different factors as opposed to being tied to, let's see where my things are, as opposed to being tied to where they are in the process. And the factors would be the public harm caused by the specific violation, the respondent's level of experience with the Act's requirements, the level of diligence in coming to compliance, and the level of cooperation with the settlement. So staff will be able to have a small range and apply those 4 factors to decide where it is in the range. The other way was, it depended where you were in the process. So if it was your first contact, then you got this amount. And if it was before probable cause report was issued, then it was this amount. Before accusation, this amount. Before default, this amount. And it was very strict for enforcement to where, if, for instance, if they are issuing a probable cause report to toll the statute, or if the respondent would like to see what the probable cause report says in order to see the evidence against them, then they were tied to a certain level of penalty, and without any wiggle room or discretion. So this actually gives the discretion to apply the factors equally in each case with a very small window of the variation between the penalties.
I think this is the appropriate time to ask this question. Can you explain the rationale for the original existing, having it dependent on where you are in the process? What was the original rationale that we might be getting rid of?
It's actually a similar rationale. So one of the factors is about compliance and reaching settlement. Those are 2 out of the 4 factors. That was really what we were trying to capture in the beginning. We were trying to figure out a way to say, if you settle early, you're not taking a lot of resources and you're cooperative and you want to come into compliance, then we want to be able to give you a lower amount. The problem was we wrote them so strictly that we didn't give ourselves any wiggle room for individual cases where, somebody was in medical problem, or they wanted a payment plan, but we had to toll the statute, or, so what we realized is that by giving just a little bit of discretion with small ranges, then you can address the situations better.
Will this potentially remove an incentive to settle earlier?
I don't think so, just because no one knows about this really anyway, but it is very specialized.
Bit on us, but
But no, I think that the regulations as written are really complicated, because that being in 3 different regulations where your different violations, you have to look in 3 different regulations to figure out what your result would be, I think has been problematic in getting the word out. Whereas this way with batching, you can just send a section to someone and say, this is your whole universe of your violations. But I mean, that's just selling you on the rewrite. But for what we're talking about, I don't think so, because it's in 2 of the 4 components for consideration.
Would it be possible to have, maybe not something that's rigid, but even more, because I'm not sure those 4 factors cover the same incentive to settle early. Mm-hmm. That covers what the settlement amount should be, at least that's the way I'm reading it.
The cooperation to reach settlement is factor 4.
Yes, that's right. Level of cooperation. So that could be the timing.
Right.
So I was thinking of, you're giving up the information that's being asked, as opposed to, I'd rather settle this now, in the first conversation I have with you, than 6 months from now.
Right.
To me, I saw the cooperation as a little bit different, because we've had some people who don't respond timely to your queries for information. They don't provide it fully. We saw one example today where they might make stuff up. And I think that's where I saw that differently. That's just my initial feedback. I know this is kind of like pre-notice, so that's what this section got me thinking about.
And we also have that 3rd component that enforcement specifically added about due diligence for getting into compliance, so that it addresses how much are they actually working with us.
Maybe it's sufficient to have as feedback that the interpretation of level of cooperation to reach settlement is both the timely response and full and thorough response, as opposed to being not somebody who responds timely and fully, with I'd rather settle sooner rather than later. And I'll leave that to you to determine if there's.
And which one are you saying is good and which one is bad?
Well, I like both of them.
Okay.
But to me, they're 2 different things. Under the language, if we're going to use that, and I should probably be grounding myself in the actual language, the chair's looking at me that way.
If we could, page and a line number in the.
I will work on that, getting the page and line number, because I'm focused on the memo, but I will go to the language while you continue and see if I can find a spot where I may find it appropriate to have level of cooperation.
It's in the beginning of each point 1 and point 2.
Yeah, okay.
And it is, well, actually, it's in point 3, I'm sorry, it's in point 3, the penalty section, at the first or second paragraph, let me see.
I will do that. I don't want to
Okay.
hold you and my colleagues up, but I may be able to find.
It's lines 11 through 16 on page 1.
I've got a page.
Page 1.
Okay. Of point 3?
Yes.
Okay, thank you. I will find that. Thank you, colleagues.
Okay. Okay, so then we broadened some tier 2 elements in order to include some things that are currently excluded, but we've also increased some of the tier 2 penalties when we've done that. So that there are things like, for instance, we're going to go over in some of these hypotheticals, and like, for instance, in the advertising sections. So we'll go into those with a little more detail. Okay, the 3 additional types of violations that are being added this time around. The first one is contribution limit and ban violations. They'd be capped at $1,000 over the applicable limit or ban. $500 cap for tier 1, $1,000 cap for tier 2. This was in response to not only new legislation that addresses excessive contributions and how they can be returned or remedied within a certain amount of time, or they can be attributed to another campaign. So this kind of opens the door to those types of violations and timing on how long it would take to do that. And then also a discussion about the lobbying ban and receiving those contributions as a candidate and being able to deal with those in an expedited manner. Okay. And then section 84308 will be the shortest discussion we're having today because we're still a work in progress on those. And so even though that they're in there, they're more in there as a placeholder. Some of the legal division staff that are experts on this were on vacation, so I wasn't able to pick their brains directly, so I'll be doing that in the month of December. And we'll clean these up and make them. But basically what we're trying to do is the minor disclosure violations and possibly considering something that's over $250 but capped at $500 or something like that to be able to get those. And the violations would be for the officer, the party, and the participant. So we'd be looking at all 3. Recurring contributions, as you know, that this is a section that has a lot of very specific requirements for timing and disclosure. So it's ripe for streamline because if you can do something within a certain amount of time, but not too long, and you can remedy it and make the person whole, then this could be a streamlined violation waiting to happen. So I think that this is an appropriate area to be added. So the hypotheticals we're going to go through are campaign late filing, which is going to talk about the population thresholds, cash contributions and expenditures of $100 or more, campaign bank account, ads, and major donor filers. So here we go. Hypo 1 is Stockton City Council, and Hypo 2 is Sacramento City Council. So they each raised $20,000 for their election. They raised this all during their first pre-election period, and they filed that statement 13 days late, but before the election. Stockton's population is 3,200, what is it? 321,800, yeah, I need glasses, but that was in 2022. If you're looking at the 2020 census information, it was a little lower, but it's these are the 22 numbers, and 528,000 for Sacramento. So same amount raised, similar jurisdictions, but not exactly the same. So let's go to the next slide and see how these would be resolved. So basically, Stockton would not qualify for tier 1 because the population cap, the activity for that amount of population is capped at $16,700. So this $20,000 would not be able to be in tier 1. So under tier 2, it would be a $400 base penalty plus 1% of the contribution received. So it'd be $600 minimum if they settled with first contact, up to $1,600, which would be, $1,800, which would be if a default is written. Then for, under the rules that we're proposing, The proposed limit is 25,000, so both would qualify for Tier 1, which would be $200 plus 1%, which would be $400 up to $800. And it would be based on those 4 criteria that we talked about: level of cooperation, the diligence in coming into compliance, the public harm, and the level of experience with the act's requirement. So in Sacramento City Council's hypo number 2, it would be between 400 and 1,000, because that would be Tier 1. So what you're noticing in the first hypotheticals under the current law, the difference for Stockton is that it would be between 600 and 1,800, whereas for Sacramento, I think I have those backwards. I do. It would be between 400 and 1,000. So just by the populations being slightly different, then they would have a different penalty amount. Whereas under the new proposal, those would both qualify under the local amount. Anybody have any questions? Okay. So here's cash contributions, expenditures of $100 or more. Hypo number 3, candidate for city council has $3,000 of activity on a campaign statement, which was filed timely and mostly correct. $800 was received in cash and reported on the statement. In hypo 4, they had $3,000 worth of activity. They filed it timely and mostly correct. $800 was received in cash. It was reported on the statement, and it was used for personal use. I think she knows how this one's going to go. Go ahead. So under hypothetical 3, under the current law, they would be excluded from Tier 1 because the percentage of cash contributions exceeds 25% of the total campaign contributions for that reporting period. And they would also be excluded because the reporting was not 100% correct. They would wouldn't be included in Tier 2 because the percentage of cash exceeds 25%, but not more than 50%. So the penalty would be proposed $400 to $1,600. Under the proposed law, it would be a Tier 1 because the total amount of cash of $100 or more does not exceed $5,000. And the failure to disclose properly was only a de minimis amount. So this is a problem enforcement has identified, that most people's campaign statements are not perfect. And so they would like it to have a little bit of wiggle room as a de minimis amount of error in the campaign statement reporting. The name can be a little wrong, or the date can be missing, those kind of things. Hypothetical 4, they would be excluded from all programs because of the personal use. That's like the gimme on the test, right? Everybody knows that one?
And we're not changing that.
No, Under everything, it's not permitted.
What is, we use the term de minimis. I think you just mentioned that that's something that staff already uses.
Right.
What does that mean in practical application? Like, why is this amount de minimis?
So we use it in campaign late reporting right now. And basically what it's used for is to have minor errors be able to be included. It's usually a small percentage of the amount. The reason we don't use an actual percentage is because for small committees, if you have, say if you're talking about campaign reporting and you have 4 entries for your 4 contributions you received and you make a mistake on one of them, that's 25%. So in a percentage, you would not think about that as de minimis, but if it's only part of one entry and it's not very much money, you're going to think, well, that's de minimis. Or if it's, a small amount compared to the other ones, then you're not going to be as worried that they didn't get the occupation employer exactly correct in the campaign setting. So it's similar here.
So what if it was $1,600 in cash?
16 out of 5,000, is that what it is?
I think you had 3,000.
Right, but we're only talking about the reporting wasn't exactly right. We're not talking about the money. We're talking about how it was reported, because one of the requirements right now is it has to be exactly reported correctly.
Yeah.
And so we're saying, it wasn't exactly reported correctly. We're not talking about what the money part is.
Okay. What if they didn't report 400 of the 800 on the statement? Because you say that the 800 was received in cash and reported on the statement, so I presume that means 100% of the $800 was reported. Suppose they only disclosed 400 of the 800. Is that de minimis?
I think not reporting half of it is not de minimis. That's not what we're talking about. We're talking about your reporting wasn't 100% correct. So say you have $800 and it's cash, and you wrote cash received $800 and you don't put a date on it.
Yeah.
Then we're going to consider that more de minimis because we know the reporting period for that, and we can get that fixed. If somebody who didn't have a bank account open and they say they didn't put $400 on there, but then they amend and they put the $400 on there, and you can see that it was an unintentional violation, they didn't even know they needed a campaign bank account, then you're going to want to be able to have the wiggle room to say, these are the types of people that should be included in the streamlined program, and we're going to consider that de minimis.
Yeah, I don't agree with that premise at all. And I also don't disagree that a particular percentage may tie your hands too much. What I'm trying to kind of probe about is,
Right.
you know, I think the absence of standards entirely also could lead to, you know, I worry about like results being consistent always
Right.
then. Like, is everybody applying the same standard of what de minimis means? So
Well, that's why you have a chief, right?
Assurance of that.
Yeah, and that's why you have a chief, because you have somebody that says, you know, this is what we're accepting, and this is not. And so having somebody that is, you know, educated and knows what the commission wants and reflects that, they can also change that as the commission changes. So when 3 new people come on the commission and they have a different definition of what they would be like, we don't care, that's no big deal, then they can accept more. So it's written that way on purpose in order to be able to be reflective of the current commission's makeup.
The commission knows about this, of course, because it's reported. in
And we
the
review
report.
these about, exactly, we do this and we review these about every 2 years, and we try to make sure that we're on the pulse of what the commission wants without actually, you know, pushing too hard on that pulse. Commissioner Wood had her hand up too, just, so you know.
Oh, someone else?
Yeah, let's Commissioner Wood and then Commissioner Wilson, yeah.
Well, I'm going to derail us back to hypos 1 and 2, so I can wait for Commissioner Wilson if he wants to
Are
stick
you
with us.
hypo 3 or hypos 1 and 2?
I'm neither hypo.
All right, let's go with that, then we'll go back.
But, you know, Executive Director West, you know, you gave the example of, you know, the commission turning over time, even though I'm sure most of us would love to be here indefinitely. But given that, how does it impact the staff? If, you know, the commission is changing and let's say 3 commissioners are appointed and they want to change how the process works, what's the real impact on the staff, given that potential scenario?
That's a good question, and it's why we chose to put this into regulations. So it's harder to change them. So then that way staff has something to rely on. And it's the same way that staff reacts to mainline stipulation changes. So as the commission gives feedback on mainlines, then staff takes that, and as they go forward, they incorporate that viewpoint into the next mainline that they present.
And I'm also assuming that, you know, because the, you know, chief of enforcement is providing leadership to the rest of the staff and attorneys, is how wide, what's the range of institutional knowledge throughout, you know, the enforcement division, given the potential for, you know, turnover, somebody moving to a different position?
Yeah, and it's a good point. It's, again, why it's all in regulation. So we put it on the record, we have these discussions, we make sure that everybody knows what's going on. There's also 2 assistant chiefs in enforcement in order to help with the day-to-day and to make sure that everybody is understanding the same message.
Okay, that's a very good response, thank you.
Thanks. Commissioner Wood.
I'm sorry to go back to this. I want to make sure I understand hypo 1 and 2 and why you said you had them switched, because I can't for the life of me figure out how you switch these. I think they're actually correct. but maybe you can go and explain a little bit more. Because if they're correct, we need to be able to, like, in this public meeting, get that on the record. But if they're switched, we need to understand why also for the public.
I'm getting my glasses. Okay, so Stockton is smaller, and they're right, yeah. They are correct.
They are correct, right?
They are correct. For some reason, I freaked out that I saw Stockton and Sacramento, and I messed them up in my head. And I was like, why did I pick two S's?
As somebody who does math on a whiteboard in front of people regularly, I feel your pain. So I thought, I think she's right, and I think now I'm confused. So anyway,
No,
thank
I
you.
appreciate it. I should have picked something with a C or something.
Thank you, Commissioner Wood. That was
You're welcome.
excellent clarification. Commissioner Baker?
I was going to go back to de minimis, but I'm sure glad that Commissioner Wood was doing the whiteboard math. I just want to observe that, so I've heard two things. One is that it's so things that are not written down, for which there aren't standards, it's a good thing there's a chief and executive director. But I also hear that we need to have things in the regulations. And I'm sympathetic to the chair's point that if we don't want to be, what you don't want to have is arbitrary, where people are treated differently for similarly situated. So, are there no bounds that say what de minimis includes? Is it really up to the judgment of the chief and then ultimately the executive director? Is it really nothing? It's just institutional
I
knowledge.
understand
I've
your
been here.
hesitancy here.
It's not directed to individual
No,
personalities.
no,
but-
I get it. And it's only used twice. And the reason it's only used twice is because we only need it twice. Because when you're applying cash contribution rules and late contribution or late campaign statements to small committees and big committees, it just needs a little bit of wiggle room. And we're not talking about a lot of wiggle room because de minimis is defined in every dictionary in the world as not much. And so I'm just, I'm not quoting. But so it's a term that's recognized not only just in the world and speak, but also in law books. And so it's not something that can be abused, in my opinion, that we have to worry about it. It's only used in 2 instances in these regulations, and I think it's where it's needed to be, because it just needs a little bit of discretion in that section, in that moment, in order for it to be applied equally to very small committees, but also be a general rule that can be applied to larger committees.
Thank you.
Yeah, I guess I would just add to that point 2 things. One, it's been something that staff has been using for some period of time and, for a little bit plus years here at the commission. I mean, I don't think I've seen or identified in my time a circumstance where I thought that the use of that standard had been abused by staff, for what it's worth. And secondly, the reason I can say that is because you report out on the streamline resolutions. And so I think, I asked the question intentionally because I think it's important that we understand that we have a term that isn't defined. I think it's also just a reminder to the commission that we're receiving this information, and the purpose of that is so that we can perform that oversight function. So if we see something that's out of whack, we have to speak up and do that. So I just wanted to offer that.
Right. And you should know, just as part of my job, I always review all the streamlined steps that are on the agenda and provide feedback when there's any feedback I think needs to be given, just as an extra check. Not that, it's like, okay, executive director, what are you talking about? But I like to think that they're good comments. All right. So is everybody done with 1 and 2 and 3 and 4? All right, then we'll move on. Sorry about that. Okay. So campaign bank account, hypothetical 5. The total amount of all expenditures not deposited in a campaign bank account during the statement period by the candidate was $5,000, which was all the expenditures made during that statement period. And the expenditures were properly reported. And in 6, that amount is $15,000 which was 25% of all the expenditures made during that statement period. So we have $5,000 in expenditures made outside the campaign bank account, and then we have $15,000 out of 25%. So 100%, 25%. So this kind of ties into that conversation that you guys had earlier when you were talking about the regulations, where one of the proposed regulations is about money market accounts. One of the things that you'll see is people making expenditures out of the wrong account. So when there's a person in audits that Luz Benetti, and she and I used to do campaign training together. And she always makes this big, ugly alien balloon head in her PowerPoint and shows you all your money's got to go into the balloon and you can do whatever you want with it, but it's got to come out of the balloon. It's got to come out the only entrance and exit. So this is something people struggle with. So when you are first starting and you want to put out a mailer, but the bank account hasn't given you, or the bank hasn't given you an account yet, you don't have your number from SOS, it's pending ID, you make this expenditure. So you see this with smaller campaigns that haven't been educated on the proper alien balloon head. So then we get them on board and they get it figured out. So under the current law, since the contributions not processed through the campaign bank account was 100% of the, this should all say expenditures, but I didn't change it, I apologize. The expenditures, then it was 100% of the expenditures made during that statement period, then it would not qualify for tier 1. And because tier 2 is only written to include 10 to 40%, then it would be a mainline stipulation. So this small committee that had one expenditure outside their account was all that they did would come to you as a mainline. And so we didn't think that was the correct result for that. So under the proposed changes, it would be a tier 1 violation because even though it's 100%, it would be less than the threshold. Since the amount is low, this qualifies for tier 1. It would also qualify for prep if the other prep requirements are met. So it has to be somebody with less experience in this type of violation. The penalty would be $150 to $550. And then for a hypothetical 6, it would not qualify for tier 1 because it's above $10,000 and 10%, but it would qualify for tier 2. And then under the proposed rules, it would also be tier 2. So that would be really similar outcome for the 15,000, which was 25%. Any questions on everything that's supposed to say expenditures? Oh, you think you get it. You think you get all of the changes. Okay, now you get to hear Chris's voice instead of mine.
All right, I got the fun assignment, the one that doesn't have as many numbers. So I'm going to have a couple of advertising and mass mailing hypotheticals now. I try not to read off screens, but I am going to read these hypos just because there's a lot to these ones. So the first hypo for ads, which is hypo number 7, reads, a group of like-minded friends create a small, local, primarily formed committee to support a school board candidate. The committee raises and spends around $3,000 to create some print advertisements supporting that candidate, which are then distributed to a limited group of potential voters. The candidate is unsuccessful, and the committee terminates after the election. The committee correctly reports its advertising activity on its campaign statements and reports. However, due to the involved individual's low level of experience and sophistication with the act, they fail to include a disclaimer on the advertisements, and it was not otherwise evident who was responsible for the ads. So here, the advertisements were required to include a disclaimer displaying ad paid for by, followed by the name of the committee, along with the required not authorized disclaimer for independent expenditures.
So this is an IE committee?
It's not an IE committee, but they are making independent expenditures.
Okay.
So under the current law, there are 2 exclusions that would apply here. First, for advertisements that are likely to result in confusion regarding the identity of the candidate or committee responsible for the ad, even if the relevant activity was disclosed on a campaign statement, they are excluded from Tier 1 and not included in Tier 2, so mainline. There's another exclusion that is relevant here also, which provides that ads that contain more than 2 of certain enumerated disclaimers in the regs, which includes the paid for by requirement, the committee name, the top contributor, and the not authorized disclaimer, are also excluded from Tier 1 and not included in Tier 2, so would be mainline. Applying the current law to this hypo, this type of violation would be excluded from the Streamline program altogether, since the ad was likely to cause confusion regarding who was responsible for the ad, and then also would be excluded under the criteria that the ads contained more than 2 of the enumerated disclaimer errors. In particular, it was missing the ad paid for by language, the not authorized disclaimer, and the committee name requirement. Under the proposed regulations, these violations would be included in Tier 2. The new law provides that the violations would be included in Tier 2 if the violation was inadvertent or negligent and was disclosed on a campaign statement or report, but was likely to result in confusion regarding the identity of the candidate or committee responsible for the ad. For that second criteria, it's been changed, so now violations are included if the ad or mass mailing contains no more than 3 of the certain enumerated disclaimers, which now includes committee name, top contributor, and not authorized disclaimer. Only one of those errors can be a missing top contributor. So if you had 2 or 3 top contributors, only one is going to count towards that. So here, under the proposed regulations, in this hypothetical, the advertisements would qualify for Tier 2. So instead of receiving a mainline fine, they would be assessed a total penalty of $1,720 through the new Tier 2 penalties. So it's still a higher amount, but it's going to be within the bounds of a streamlined stipulation instead of a mainline. We believe this provides a fair result given the other mitigating factors that are present here, such as there was a low level of experience, the committee terminated, their supported candidate was unsuccessful, and they had no prior history. And all of these mitigating factors are otherwise included in the streamline regs as warning letter criteria. So something that we would carry a lower level of public harm. Yeah. Does anyone have any questions about hypo number 7?
I do.
Yes.
That's great. This is a lot of fun for us. So I had a question about the top funders. In the provision, I'm looking, it's proposed regulation 18630.1. In my packet, it's page 13, little I3. Right. Last sentence, only one of the errors can be a top contributor.
Right.
So the requirement is you have to list the top 3 contributors, right?
If you have 3.
If you
yes.
have 3.
Yes.
So am I correct in understanding then, if you, let's say you have 3 top contributors, but you completely omit the top contributors, does that take you out of this? Because that's 3 errors related to contributors. That's what I'm trying to understand.
Right. So the new proposed reg says no more than 3 of the following, and you don't have more than 3 of the following. You have 3 top contributors. I don't think it would be excluded. Is that your interpretation as well? I think that would only apply if you had top contributor disclaimer errors in addition to the other ones, committee name missing and not authorized missing. I don't believe the intent is that automatically excludes you if you have more than one top contributor, but I could be wrong. That sentence is carried over from the last, is also in the current law too.
Yeah, I'm just trying to get an understanding of what the intention is there. Would it be fatal for purposes of streamline if I didn't disclose any of the top 3 contributors? Yes or no?
Under the current and proposed, it would be fatal because only one of the errors can be a top contributor.
Yeah.
So that is considered 3 errors. Only one can be top contributor. You can only be missing one.
Right, and that's because of the particular value that we attach from a policy standpoint to contributor information being
Exactly.
given to the voters, right? Okay, I just wanted to make sure I understood that. Then my second question, Mr. Burton, is that I see you tell us what the penalties are for Tier 2 here. That's great. What about prep? Is there a reason that this would not, as you described the hypo, it sounds like a group of friends get together for the first time supporting another friend who's running for school board. They're not sophisticated actors. There's no history of violations. To me, this screams of they need more information to comply in the future. Would this qualify for prep?
Yes, under the, I'm sorry, it would not, because it would be under Tier 2, and so technically it would not, because it meets the Tier 1 exclusions, which also excludes it from prep.
Why?
How we've generally written the first go at this is that we figured the most inexperienced people with the most limited amount of harm violations would be Tier 1. So Tier 1, having the least amount of public harm, could be diverted into the prep program and get educated and not get any penalty associated with that activity. Whereas when you get to Tier 2, it would be a policy decision of the commission, because those are a little bit more harm, a little bit more activity. Some of the thresholds are higher. And so you're saying, you don't have to get a penalty for this, we are going to educate you. So I think that would be much harder. In this case, you have an inexperienced group, but even if they're not experienced, that you could apply the max penalty in this because of their having more experience, but having less experience doesn't push them down to prep.
Okay, well, that's some food for thought.
Yes. Kind of a follow-up question, without getting into specific cases. Do you ever find a situation where, presumably through a respondent's attorney, they're arguing to be in the streamlined program? Have you ever run across that scenario?
I think if we have sophisticated opposing counsel, yes, they'll be familiar with the regulations and try to make an argument. So yeah, we certainly do.
Okay, just curious. Thanks.
Commissioner Baker?
So both of my colleagues came up with questions a little bit similar to mine, but on Mr. Wilson's question, Commissioner Wilson, excuse me, so we don't tell people if they qualify for Streamline, or do we? How does somebody, get the benefit of Streamline? I'm assuming you would tell them, but.
We don't tell anyone ever. No, I'm just kidding.
And in all fairness, how do they find out? Because half an hour ago, it was sort of mentioned that nobody knows about this.
No, I was saying that nobody knew about, say, the population thresholds and the weeds of it.
Yeah.
And the penalty structure is what we were talking about specifically, about if you wait till a PC is issued, you're going to get a higher penalty. That is through your contact with enforcement staff. So enforcement already has procedures in place for Streamline, and basically when they have cases, then they make an evaluation pretty early on, and they contact the respondent with their options. And now those options include prep. So they're notified pretty early that these are the more expedited options that are available to you, and we could get this done right now.
Yeah, good. I guess where I was going with that is if you ever feel it was appropriate for folks who don't have a lawyer who is in the weeds, to, maybe it's part of our notification is that we do have a streamlined program. If you think you qualify for it, feel free to pitch it to us. But right now, this is what's happening, because they might not know. And if you disagreed and you don't think it's streamlined and you just put them right into mainline, I just offer that as to think about if that is fair for the person who doesn't have a lawyer who's going to say, hey, wait a minute, I think we qualify for Streamline, and I want to advocate that. My second point goes to, I just want to underscore the scenario that you are doing really does rely on innocent, didn't mean it, not intentional, or even close, because we've, to not include add paid for by. In this last year, we've had things come to us where they didn't include paid for by, and that is a public harm. And I think it's why I'm not sure I would necessarily make prep available, because there is a public harm to not disclosing in a city council race who paid for the ad. And I just wanted to weigh in on that point that I wouldn't necessarily go to prep or that program just yet. Less because of the tier 1, tier 2 question, more because there is more than a, I guess I'll say, de minimis public harm. If you don't know who the ads came from, that's pretty significant.
Commissioner Wood, anything you wanted to add?
You know, I love talking about public harm.
I do.
I mean, I agree that not knowing where the ad's coming from is a big public harm. And so I think it's still okay to go through Streamline, but to the extent, I always think of prep as more about education, but I guess it's education without penalty or without serious penalty. And so I think I agree with that, although maybe part of a streamlined step could involve doing some education. I don't really know if that is possible.
All right.
I can just put a quick spin on this hypo. I mean, if this committee, inexperience, open for a short period of time, if the only thing missing was the not authorized disclaimer, but they had the committee name, then that would be in tier 1, that would go to prep. So there are other iterations where prep would be appropriate.
All right. Well, that's helpful. That's helpful. I understand. Commissioner Ortiz?
Yeah, and I don't know if this is the appropriate time to ask the question, but it was raised when I read the like-minded friends who created a committee and they failed in putting the ad, whatever, they didn't follow the law. That committee then ends when that election happened, and then the penalty happens after that committee was closed, versus an active committee of an elected official. They can use money from the active committee to pay the fine, correct? The little-minded friends who close the committee have to pay out of their own pocket?
Generally. That's why all of these expedited rules are so important, because we're trying to get to these earlier before these committees are closed so that everybody has the same opportunity, whether they are one-time committees or ongoing committees. So the whole point, I mean, you really are hitting on the whole point of this. The whole point is to get to these faster. The whole point is to get people participating quicker. The whole point is to intervene and to have an expedited way of handling it. So yes, there are certain reopenings of terminated committees that I won't go into details, but generally people don't reopen their committees to pay a penalty. But like Mr. Burton was saying, that if they had just a couple less violations, they would be going into a prep program with no violations, with no penalty associated. So, this is the whole purpose of this. This is the whole reason we're adding a couple more violations to this. This is why we revisit these every couple of years and tweak them and show you who isn't qualifying and who needs to be in this to reach the goals that the commission is setting. Thank you.
I think you've kind of answered my question, but kind of on a
I could use a softball at this point. Go ahead.
well, I'm going to throw you a basketball question. No, as a follow-up to, Commissioner Ortiz's question, he talks about, the buddies that got together and they established this committee and then it was dissolved and they had to pay the money out of their own pocket. Then you have the committee that has tens of thousands of dollars. They write a check, they pay the fine. What happens when it's a local government that's in violation? Who pays the fine?
Local government, unfortunately. I mean, that is something that has been a bone of contention for the commission for many years, going back to the BART case way back when. And unfortunately, that's the violator and that's who's responsible. There is some individual liability that comes with that in certain cases, and everything is joint and several liability under the Act. So there are specific cases where you can go after an individual, but most generally it's the pocket of the entity.
Okay, I have some other questions, but I'll refrain from asking those.
We have those offline.
Thank you, Commissioner Wilson. Any other questions on this set of hypotheticals? All right, go ahead, Ms. Burton.
We do actually have one additional ad hypo. I think we've touched on a lot of stuff already, but I'll try and get through this one quicker. The controlled committee, Kittle for Monterey City Council 2022, paid $600 for a mass mailing that included the disclaimer paid for by Kittle for City Council, followed by the street address and city of the committee. Although included, the paid for by language was in a color different from the committee name and street address and city. Here, the mass mailing violated the act in two ways. Number one, the committee name was incorrect in that it failed to include the full name. It was missing a couple words. And the paid for by language was not presented in the same color as the rest of the disclaimer, which is a requirement. So here, under the current law, the violations would be excluded from Tier 1, so they'd be in Tier 2. Because the Tier 1 exclusion is that if there's two or more missing or incorrect disclosures or display requirements in the disclaimer, and the ad contained one or more of the enumerated disclaimer errors, then it's excluded. So here, the committee name requirement was an incorrect disclosure because it was not the complete name, and the wrong font color counted as an incorrect display requirement. And that's what kicked it out of Tier 1. Under the proposed regs, the violations are excluded from Tier 1 if the ad or mass mailing contains two or more of the enumerated disclaimers. However, we've removed inclusion of display requirements, such as the font color, as an error that can count against you in terms of which tier you're in. So under the proposed regs, the mass mailing here would not be excluded from Tier 1. So instead of receiving a Tier 2 penalty of $406, the violations would qualify for a Tier 1 penalty of $206. This provides a fair result in this hypothetical since the display requirements error the wrong font color. It does carry a low level of public harm generally and is indicated by its inclusion in the list of minor violations that would otherwise qualify for PrEP or Tier 1. Also, the committee name error is less egregious since there was likely no confusion regarding the identity of who was responsible for that ad. Are there any questions about hypo number 8?
So this would qualify for PrEP as well?
Yes, it would.
Okay.
Yes, it would.
All right. Just wanted to clarify that. Commissioner Baker?
I don't think I have a question.
Okay, sorry.
No, I was pointing out, I think your slide's a little bit different than our printout here, and it's no big deal because the chair just asked the question about PrEP. There's a slightly longer paragraph. It's not a big point. Thank you.
All right.
I would take this moment to point out that PrEP is voluntary, is a voluntary program that you can participate in. It's not mandated. So people can choose to pay a penalty and not be educated.
Right. Yeah, no, I mean, I understand that. I just, for the sake of clarity,
I'm just letting you know.
Because as I understand, a lot of what you've done here is the eligibility is Tier 1 or PrEP. So it is, as you point out, it is truly a choice. But since, at least on the handout I have, it only referenced Tier 1, I just wanted to make sure it was PrEP too. Good.
Kind of a related question, though. If you opt out of PrEP and decide to pay the fine, then that's going to be public information. But if you go into PrEP, does the public know you opted for PrEP?
It's not a black site kind of program, so it is very public. And in fact, we do report how many PrEP cases for SEI in our executive report under the legal division. And we're considering some enhanced reporting on the website as to participants in PrEP, which would be the same as because if you check in the enforcement case management complaint portal, you can see when someone has completed PrEP, I think.
All right, that answers my question. Thank you.
Any other questions on hypo 8? All right.
I want to point out one additional change that is being proposed. It's not one of the big ones that was on the slide initially, but it does kind of relate to advertisements. So the campaign filing portion of the current Streamline regs excludes from Streamline entirely Any 24-hour report that's filed more than 5 business days late, where the timely reporting of the contribution would have required a change to the top contributor's disclaimer on advertisements. It's our belief that there are numerous issues with this exclusion. First, the language is technically inaccurate since the changes to the top contributor disclaimer on ads are not triggered by any 24-hour report filing requirement. They're triggered simply by the contributions being received by the committee. Further, this exclusion, we believe, is somewhat redundant and unnecessarily increases the penalties tied to a top contributor issue, since the core issue is the top contributor's disclaimer, and as we've already discussed, the advertising streamline regs address that disclaimer, which, as we've talked about, is seen as aggravating. We didn't believe that there was a need to also have this duplicative and harsher penalty tied to the 24-hour reporting as well. And then finally, when we looked at it, a contributor qualifies as a top contributor upon making a contribution of $50,000. Under the new rules, the related 24-hour report will usually already be excluded from Tier 1, given the new thresholds, $50,000. And so for these reasons, this is another change that we are recommending be made.
Nope. Okay. All right.
You made eye contact. Okay.
I would say that's not something that's addressed in our slide deck.
No, that was just something that Chris is going to mention in the advertising portion, because it's more of a minor change, because we found it to be redundant and not really applicable.
Yeah, and I followed that, and I think that sounds good. I would just request for the next time we talk about it, that something be included in the slide deck on it. It's just easy to follow. I know it's a small change, but there's
It's in the memo.
But I know, and I have to flip between 3 documents.
Okay. All right, so these are the last 2. You guys are doing great. Everything's good. Everybody's still hanging in there. So major donor filers. As you know, someone qualifies as a major donor and they have to file reports. And we've had them in Streamline for a couple of years now. We actually thought we were smarter than the people that did it in the beginning, and we had them all with campaign statements. But major donor filers are such their own that they really just make contributions and they don't really have any other activities. So they really needed their own category. So hypo number 9 says a first-time major donor makes a single contribution of $75,000, does not file their campaign statement timely, but the recipient of the contribution did report it timely. And then hypothetical number 10, the major donor with no history of violating the act makes multiple contributions throughout the year, ranging from $1,000 to $50,000, totaling $80,000. Fails to timely file multiple campaign statements and reports, the recipient committees timely file. So hypothetical number 9. So this is the one statement, and it was stemming from the $75,000. They would not qualify for Tier 1 under the current rules because the limit was $50,000. And so they would qualify for Tier 2 with an $800 to $1,400 per statement penalty. And hypothetical number 9, under the proposed rule, they would be included in Tier 1 because we extended the cap to $75,000. So the reason for this is pretty basic. If you look at the contribution limits for the governor's race, it's $36,400. So if you're just a one-time political contributor and you max out primary general for the governor's race, then you would automatically be in Tier 2, not eligible for prep, not eligible for anything. So this seemed like a very logical extension to $75,000 for Tier 1. For hypothetical number 10, under the current rules, since it's more than 2 statements or reports that were late during the calendar year, that they would not qualify for any program under the current rules, and it would be a mainline. And that's just because there is a rule excluding 2 or more statements or reports that were not filed timely. And so our proposal would be that they would qualify for Tier 2, And the exclusion for limiting participation to less than 3 statements or reports was removed. It would be an $800 to $1,200 penalty per statement or report.
So I have a question. So in hypothetical 10,
Yes.
well, actually in both hypotheticals, suppose that the major donor makes the same contributions you have listed here. They don't file their statement because they're brand new, and this is the first time they're doing it, let's say. But the recipient committee also fails to timely disclose. Does the major donor still get to take advantage of Streamline, even though there was zero public disclosure?
Right now, that's not a requirement, but it is something that we're talking about internally if we're going to add that as a requirement for the recipient to have disclosed it timely. I actually hadn't thought about it until I wrote these hypotheticals, and then I was like, why is that so important to me that the recipient has timely filed and then it's not in the criteria? So it was an issue that I was going to bring up today to talk about not only that, but I was looking at the penalties and I was like, oh, is $800 to $1,200 enough for this amount of money? But it is per statement or report that wasn't filed timely, so it does add up. So I convinced myself that that was an adequate penalty for the activity, especially for someone that does multiple contributions. But yeah, so that was something that I was thinking about because it is not currently a requirement.
Okay. And then my second question with respect to hypothetical number 10. So taking a step back, my general understanding is that Streamline, much like PrEP, is kind of like you get one opportunity at it. You make a mistake, you're first time making the mistake, you're qualified for these expedited processes, right? If you are a repeat offender, then you don't qualify anymore. So here we have somebody who made multiple major donor contributions throughout the year, missing multiple or crossing multiple statements, right? So how does enforcement, do you treat that as one violation for purposes of Streamline? Because I think another way of conceptualizing it is the first payment made that missed a report was your bite at the apple, and anything after that wouldn't qualify. But can you kind of walk us through how that works?
That's interesting, and it's something that we talked about many years ago when the commission was first starting to use the terminology that someone was excluded from a program for 5 years after receiving a penalty from the commission. So the wording was chosen so that if you had a contemporaneous violation, that you hadn't learned from that violation yet, because you hadn't been taught that that was wrong. So the decision was made at that time that the 5-year prohibition would be on things that were moving forward from once you were pretty much taught the lesson, let's say. It was brought to your attention. Because, I mean, it's like a kid, right? If they keep doing the same thing wrong over and over again and no one's ever told them it was wrong, then when are they put on notice that it was wrong? So it was a similar thinking that it's when you get a penalty, then from there forward, you're out.
Okay, and so then kind of crystallizing that here, even though there were multiple payments made over multiple statements, it's considered one violation conceptually for eligibility for Streamline. If they, after this resolution, if they made the same mistake in the future within 5 years, then they would not be eligible for Streamline. Is that right?
That's exactly right. And if you think about it, it's easier to apply with different types of violations as opposed to the same violation more than one time. So you filed your report late and it didn't have all the information that it needed. So those are two different violations that you did at the same time, so you still get streamlined for those violations.
Okay, thank you. That's helpful. Commissioner Baker.
Thank you. I'd like to go back to the first, both of these hypotheticals. If I'm remembering correctly, may not be, a major donor situation, does the recipient committee have to notify the major donor that they may have to file?
That was my question.
Okay.
Yes, and
So-
we have, there's actually a violation in Streamline for the people that don't give the notifications on time.
This didn't appear in your hypothetical, but if the person if the major donor received that notification, I mean, actually, it's quite common that the recipient committee doesn't notify a major donor, but if they did, does that affect your analysis here? If Mr. or Miss Innocent in hypo number 9, who, cut the check once, got a notification that, by the way, you're supposed to do this, thank you for coming, and they didn't do it, would that impact Streamline or the penalty? Not so innocent, well, or maybe negligent, Remember, I'm a cynic, or not, depending on the meeting.
So under the current rules, under considerations for warning letters, so this is the additional materials, so it's slide 50 in your giant slide deck. The considerations for warning letters would be a first-time major donor filer, the individual committee was not sent a major donor notification as required. So that is a consideration that is taken throughout the considerations for Tier 1 and Tier 2 as well. It's like what Mr. Burton was saying was that when you're looking at it and you're looking at how bad the violation is, you're also looking at the other criteria that we consider for warning letter to determine, how serious the violation is. And so we also keep that in the proposed regulation for major donors, that the warning letter is if they weren't sent a major donor notification as required. But then the exclusions for PrEP and Tier 1 are only the amount and if it was a 24-hour report. So it's
yes
considered. So it's considered as something that you will look at on whether or not they get a warning letter as opposed to a penalty.
So, which means no with respect to whether you can be in Tier 1 or Tier 2?
It means you can be in Tier 1 or Tier 2. Yes, it's not an exclusion.
Okay.
But you could actually get a warning letter if it's a small enough amount and you were not notified and it's your first time ever participating.
Okay. I understand you might get a warning letter as opposed to even needing to go through Streamline, because a warning letter means you get a warning letter. You're not getting a penalty. You don't need to think about Streamline. I guess my feedback is if we need to make it more explicit anywhere, that could potentially also factor into the Tier 1, Tier 2, or if we're just giving you discretion to decide. I think it's relevant if the recipient committee did or did not get notice, because then you've kind of potentially ignored something.
So, okay, let me think it through. So right now it's a consideration for warning letter, which also becomes a consideration for what the penalty and the range is, because then that's the seriousness of the violation.
Okay.
Whereas if we move it to a Tier 1 or Tier 2 criteria, then it would have to be present for you to be able to qualify for one of those tiers, which is more problematic, because then you're talking about, instead of taking it into consideration, it has to exist in order for you to qualify.
It seems like what you're saying is the distinction is eligibility versus whether it's considered for purposes of setting the penalty amount.
Exactly.
So then the place to look is 18360.3 and the factors you use in considering the penalty, right?
Right.
And so would it be the level of experience or the level of diligence to come into compliance that you would factor the absence of notification from the recipient committee in?
I think it would be level of experience, because the notification really only comes into play if you're inexperienced. Because say you are a very experienced major donor and someone doesn't send you a notification, does that really impact your responsibility in filing when you've already been experienced in that exact motion?
Well, if you've given the money, if you've written those checks a lot of times, or maybe multiple times in one election cycle, and no recipient committee's ever given you the notification, which I think we found sometimes happen, I would question that.
But I mean, I'm saying if you already were a major donor filer, you already have filed statements in the past.
Oh, I see. If you are a filer, you've complied with it before. Okay, gotcha. I had a follow-up that's unrelated to this, but I'm done with that point, if that's okay.
Well, on this point,
Yeah.
Commissioner Ortiz?
I had questions kind of in the same vein, but you mentioned that
the person, the major donor who did not receive the notice or the warning from the committee, you had to file this. And then you mentioned that major donor gets a warning letter, but includes the penalty in the letter. What is the purpose of the warning letter then?
That's a good question. So I really breezed over that earlier. So the warning letter is one of the resolutions that enforcement does that doesn't have a penalty attached to it. So when enforcement evaluates a case, that they either, once it's become a case, they can close it without an action, without filing a violation. They can give an advisory letter, which says, hey, you came close to violating the act, here's what the rules are. Or a warning letter where they found a violation, but it meets these criteria to not need a penalty. Then after warning letter, the next step would be a streamlined penalty.
Okay, so the warning letter that you mentioned earlier does not contain the penalty.
Correct.
Okay, I misunderstood that.
Yeah, sorry, I said that, and then I said it's in consideration of the penalty for
Thank
streamline,
you.
and I probably just merged them together.
Commissioner Wilson?
No, my question was answered, thanks.
All right. Commissioner Wood, anything? No. Commissioner Baker, further comment?
Thank you. It had to do with your, what counts as a bite at the apple point. And I appreciate your clarification that it's like, once you're on notice, even if you did it multiple times, it's sort of like after in time. Does the amount that your mistake, let's call it a mistake, made also factor in? So let's say somebody misinterprets a rule, they make the same mistake, it could even be on the same day or in the same reporting period, but it totaled many, many contributions, 100,000. Does that basically mean because the amount that it impacted was too bad? It keeps them from having the one shot or one bite at the apple that the chair asked about. Does the dollar amount ever negate that?
Okay.
Because I can see a candidate doing that too, where they misinterpret something or they are their treasurer and they do it and it impacts a whole, maybe they had one big event where they reported something wrong and they had a bunch of checks that totaled up to $100,000 and they thought they did it right, but it was the first time they got it wrong, but it's a big amount of money. So does that keep the one bite at the apple from being relevant?
I would just say, stepping back, streamline is limited in what it can include in order for enforcement to only have this ability up to a certain amount. And those cases would be presented as mainline if they go over that threshold amount with that mitigation in it for the commission to consider. Because it seems like that would be more of an unusual case that's a one-off. We're not talking about unique cases for streamline. We're talking about it generally falls in this pattern, and this is how we want to handle them as quickly as possible.
Thank you.
And kind of to that point, I mean, another thing you kind of glossed over, Ms. West, is how much work you have put into this, including, which I have the benefit of seeing and hearing about more frequently, but I know one of the things you did is go back and look through the different mainline stipulations and rewatch and re-listen to commissioner comments about areas that we thought, maybe this didn't need to come to a mainline. So I think part of the exercise here, just as a reminder to my colleagues, is, Ms. West and Mr. Burton have gone through and they've tried to set these thresholds where, a high dollar amount isn't something that we typically see as a need to squeeze into streamline based on historical experience. That what they've done is they've identified those areas that we have said, is this something that we could get into streamline? Is this something we really need to spend this much time on? And try to expand the program, again, for efficiency's sake, pursuant to our policy directives. So it's a way of saying thank you and recognizing your work and contextualizing this a little bit more for everyone. Do you have anything further?
The only thing I would mention is in December, we'll be having an interested persons meeting to get some feedback from the regulated public on the rules. Since these are more expedited ways of handling cases, I don't really expect anyone to oppose them. I expect it to be more of input and guidance on the things that we've proposed. And as I said, we'll be working on the A4308 sections.
Thank you, Ms. West. Any final commissioner comments? Commissioner Baker?
Thank you. First of all, I want to echo, clearly you put a lot of hard work into this. We and I have to say to my fellow Commissioner Ortiz, my first commission meeting, very first meeting was, I think, the adoption of Tier 2, and it was explaining all these things. Wow, okay. So I haven't gotten much better, but I'm grateful that you have done this level of work and gone back in the meetings to find the times we said, boy, should this really be here, and why wasn't it in Streamline? Also want to just make 2 points. The first one is on that population threshold. I just want to give this feedback because it's pre-notice. I don't have a solution for you, but just put some more thought into, as I will, does it really seem right that some senators, some Senate candidates would be treated differently than others? Because when I went back and thought about your math example of some have 910,000 constituents and some have 110,000, yeah, that's a difference of 100,000, but it's kind of small compared to the fact they're senators. They have the same, very close population because it had to meet constitutional standards for equality of representation. So I'm grappling with that still, so I don't have a solution. I'm not even asking for direction. I'm asking for you to grapple, think about it more. And just, I know that'll be a question when this comes back for adoption.
Before you move on, I just want a question of clarity. So I had actually talked about this morning with one of my colleagues because I said, I bet this is going to come up because somewhere
Did you pick which commissioner was going to?
It was you. It was you. I already knew. So I'm really good at this game. But so I said, would you think that it should be included in the state or the local? And so that's the question I would put back to you guys as to, since they are so close to that 1 million, my proposal would be bringing them back in the state higher thresholds versus the lower, below 1 million. But obviously, the commission feedback on that would be very helpful.
What would that, so, sorry, just so I have an understanding about what you just said. So are you saying that you would not utilize the population threshold at all for a particular office, like state senate? Is that what you're
No,
saying?
I would change the language to where we say locals and jurisdictions under 1 million, and then states and jurisdictions over 1 million. I would put states, comma, Senate offices, or whatever the technical word would be, and populations over 1 million. So I would specifically include them in one criteria or the other.
Yeah,
so that they're
regardless
not
of the population.
Yes.
That's my point. So you
Exactly.
wouldn't use population for them.
Yeah, they would just be stated like state offices are.
Okay.
Yeah, I agree with
Folks have.
Commissioner Baker.
My second point is unrelated to this, so.
Well, I think we're going to end up in the same place, but I think, given the example that Commissioner Baker outlined, you should be given the discretion where common sense can come into play. If you have 950,000 versus 1 million, 10,000, that, at least from my perspective, would give rise for you to say, wait a minute, they're doing the same jobs, they're both close or above the 1 million threshold, so utilizing your discretion, you put them in the same category. So just a question of how you get there, so.
Fairness.
That's right. Commissioner Wood, anything on this point that you wanted to offer? All right, Commissioner Baker, you had a different.
I did. It is different. And very thoughtful response to the first one, so I appreciate that. I'm going to be really thinking about it. And just to say, I'll be thinking about, should Assembly and Senate be in local? I just got to think about that. The second one is on that, and going back to my very first comment that everybody pointed me to page 1 of 18360.3, starting at line 11, the difference between cooperating in a settlement, which to me is I'm not going to be obstructive, you ask me for something, I'm going to give it to you, and the timeliness of settlement. I'd rather settle earlier rather than later. I don't think this is the perfect language. I'm going to offer it, and this is the benefit of pre-notice, is I can hopefully set you off to make it perfect, is between lines 13 and 14, it'll say the level of diligence to come into compliance and the level of timeliness and cooperation to reach settlement. I don't know if that's right. I don't know if my colleagues would agree, but I see how soon in the process I'm willing to settle is different than every time you ask me for something, I don't, mess around and take a year to give it to you and act like I
Can you
don't
read it
put
one
your
more
words in my
time?
mouth. Yes, it's the level of diligence to come into compliance, comma, and the level of timeliness and cooperation to reach a settlement. You know, I don't know if, again, I'm throwing it out there for consideration. That's what pre-notice, I think, is for.
Okay, and so you're adding timeliness.
Yeah.
Okay.
The chair is struggling with that.
Well, I agree that we want to encourage quick settlements. So we're on the same page with the ultimate goal. I think level of cooperation can include that, and a fair reading would include that. Timeliness of settlement, like what's the standard for timeliness then? See, I don't like the current structure that's too rigorous, but it's like very specific on what is timely at each stage and at each point at which a dollar increases, right?
Mm-hmm.
When you introduce a term like timeliness without more, what does that mean?
Yeah, I appreciate that.
You know what I mean?
I do.
So
I do.
I agree, level of cooperation to reach a expeditious resolution of this matter. I mean, there's different ways.
Yeah, there are. Expeditious, true.
saying it, you know?
Just throwing it out there.
I have a feeling I'm going to be
What does
bringing
that
out
even
some
mean?
options.
So, and sometimes it takes a while to get to the right result. And I don't want to necessarily penalize somebody who, because both sides were taking their time to arrive at the right result. That's just, I agree, it's pre-notice.
That's
Should
tough.
continue.
Yeah, pre-notice the deep thoughts, but I think your point is well taken, and I will be thinking about it as well.
Yeah, email me if you guys have any ideas. Otherwise, I'll bring back some options.
Just not on the same email thread.
Not on the same email thread. Send me an individual email.
That's right.
And
I
we'll do
won't
so
tell.
expeditiously.
Commissioner Wood, anything to add?
No, no, but she keeps talking. So I think timeliness, couldn't that just be determined by like a reasonableness decision? Because our enforcement people have discretion. And so we don't want a bunch of fuzzy language in there, but I do think that stopping heel dragging is really important. And so incentivizing people to not do that is important. But I also understand that inserting vague language into these sorts of things can make things complicated in the future.
It might not need to go in the reg.
Well, it's that comment in particular just prompted a question. I should know the answer to this, but I'm going to ask anyway. When somebody enters into the Streamline program, right, and you engage with them and they're engaging with you, do you have a fixed timeline that, look, we're giving ourselves a year to come to an agreement within Streamline? Part of the point of Streamline is to get things through quickly. And so the only reason I think about that is if you had a built-in, we're only going to engage with you within the framework of Streamline for 1 year from the point of contact, you end up backing into, you can't really drag your feet. It's a different way of approaching it, is maybe, I don't know, just thought.
I'll just say our initial outreach with a streamlined proposal carries with it a 21-day deadline to respond. That can be flexible, but
Yeah.
that is our default.
Okay, so there are some timelines built into the process already. All right, well.
I think my original question had been, a while back, was, are there some standards for it? And if they're not in the regulations, but they're in your internal practices because of commission feedback, that might be the solution instead of making the regulation itself messy. So that might be one of the best options.
Yeah, something to think about. So maybe that's a different approach staff could consider when they're mulling over ways to address Commissioner Baker and the rest of us are some of the concerns we've raised here. Commissioner Ortiz, anything further? Commissioner Wilson? All right. Is there let me pause then and call for public comment. This is pre-notice discussion of proposed changes to our warning letter prep and Streamline programs. Do we have any public comment? Hearing and seeing none. Thank you, Ms. West. Thank you, Mr. Burden. I know you're doing the Interested Purses meeting next month in December, and so hopefully we'll have some additional feedback from the stakeholder community following that. All right, thank you. All right, we've already completed item 11, so that brings us to item 12, executive staff reports. Chief Lindsay, anything from the Enforcement Division report you wish to highlight for us?
Yeah,
All right, thank you. Any questions for Chief Lindsay? No? Thank you, Chief Lindsay. Audits and Assistance Division, Chief Shaw, anything in particular? All right, thank you. Any questions, comments for Chief Shaw? No? All right, Legal Division, sitting in for Mr. Bainbridge again, Mr. Lau.
Yes, I have been asked to just highlight staff's work in preparing educational materials related to 84308, and we have two comprehensive guidelines up on the commission website. One is targeted for officers and how the rules apply to them, and one is targeted towards the parties and participants and how the rules apply to them. So we're hoping that helps out the regulated community, and just wanted to point that out.
Thank you, Mr. Lau. Any questions, comments? Commissioner Baker?
Thank you. That will be my light reading entertainment later. But I wanted to say, on the Levine Act webinar, I think just from what I saw in our FPPC social media, that was sold out. And you're going to have another one. There was very high demand. Are you able to say, like, how many people did attend? And was there a pattern of, hey, they all were, maybe the questions were everywhere, but the questions might have all been in one or two categories. But kudos to our education team for a high demand program.
Let's see, we have Ms. Hackert. Good afternoon.
Hello again. Chloe Hackert, Education and External Affairs Unit Manager. So yes, we had over 300 people sign up for our 84308 Levine Act webinar, and our Zoom can only hold 300 people. And so we had to tweet out that we were at max capacity, and we were hoping to get that many people, but we had about 200, about 180 to 200 ended up showing up to the webinar. If we get over half, usually that's really good. We do them during work hours, so sometimes it can be difficult. But we had a lot of turnout and a lot of interest, so good shout out to Kevin Cornwell, Senior Commission Counsel. He did the legwork of that. I was there handling the messages and the keys in the chat. But it was a really well attended, lots of good questions, and we are hoping to host another one within this calendar year. But as Galena mentioned, some people have been out and we have holidays and vacations, so we're trying to strike the best balance on when we think we can reach the most people.
Is this something that we could offer as, like, not paid for free, but like video on demand type thing? Instead of having to be present for the webinar when you're doing it, they can download it and watch it when it's convenient to them.
Yes, that requires a bit of work. So we would have to record it and work with our IT department, but this is something we can definitely do and work towards in the future.
All right, thanks.
That was my question. Was this actually recorded? I think you answered that question. Thank you.
I was just curious if there were any patterns in the questions, like they seem really focused on who qualifies as a participant, or when can I cure this problem if I've already got it? Any patterns that you can discern from that one large meeting?
Sure. I would say that there's been a lot of questions on entitlement for use proceedings as to what qualifies as one and what would require disclosure or abstaining from the process. So it's clarifying some of those questions. And then also I would say that for like clerks and filing officials, they have some questions regarding their role in the process, but the statute is pretty plain in its language about being specific to officers, agents, participants, and parties. So there's some questions on the filing officer role, which we helped clarify during that webinar.
Thank you very much.
Thank you, Ms. Hackert. Thank you, Mr. Lau. Moving right along, Administration and Technology Division report. Chief Hahn. Good afternoon.
Good afternoon. I would like to submit the report as is, but I would like to give you an update that normally by this time we would have the first quarter expenditure report to you, but we're unable to process this month because there's been a delay at the SCO for the year end for last fiscal year. So I just got the report for September, so that would delay our reporting, and you'll be seeing the expenditure report in the next commission meeting, which will be in January.
Thank you, Chief Hahn. Any questions, Commissioner questions, comments for Chief Hahn? Thank you, Chief Hahn. Ms. West, Executive Director report? Yes. Okay. Any questions or comments for Ms. West? Hearing and seeing none. All right. Any public comment on item 12 on any of the reports? Hearing and seeing none. Final item, item 13, Commissioner comments, proposed future agenda items. Commissioner Baker. I see you reaching for the.
I'm sorry. There was a public comment that was received in advance of this meeting. And I feel like we've received it once before, and it has, so I know it's not an agendized item, and I don't know if we would get a very short briefing from the legal team on that written public comment. It has to do with, and I'm using the terminology in the letter, I think, regarding serial harassing complaints, and is there anything the FPPC can do about it? I don't want to further characterize the nature of the letter, but since we have received that before, I don't know if it's appropriate to see it. It might only take 30 seconds. This is outside of our jurisdiction or whatever. I just think it's a public comment that we've seen a couple of times. And I was curious if that might be appropriate for a future meeting. Thank you.
Mr. Lau?
Yes, we can come back at a future meeting and just kind of give you a brief little discussion of what we may be able to do about. It's not something I've thought about at this point, though.
All right. If the commission wishes to have a briefing on the future in response to this public comment, that's fine. I think what I would not want to do is, in requesting that briefing, put our imprimatur of any truthfulness, accuracy, judgment, et cetera, on the public comment. It describes in value-laden terms an individual that has filed multiple complaints with us and characterizes them. I have significant concerns with turning anyone away who wants to file a complaint with us. I think anyone in the public should be able to file a complaint with us, and we do our job to evaluate it, and if it's not meritorious, we reject it. But if commission would like to hear some presentation around that, that's fine, but I think it needs to be within certain parameters.
I 100% agree. I would not make it any judgment at all on it. I just know it's a public comment we've received, and sometimes when we receive public comment, I suppose I can go to the legal division and just ask, is this even in our jurisdiction or not? Or it doesn't have to be a full-fledged agenda item. Just wanted to put that out there. So.
Do you need a microphone, Ms.
No, I
West?
borrowed Brian's. So this is an issue that has come up in the past when we talked about the complaint regs. So it is something the legal division has explored in that context on what can be blocked, what can't be blocked, that kind of thing. So they could revisit that and give you that information that was presented at that commission meeting.
All right, any other future agenda items? Comments by commissioners? Going once, going twice. Commissioner Wood, anything? No. All right. Do I have a motion to adjourn?
Motion to adjourn.
Ms. Contreras?
Commissioner Baker?
Aye.
Commissioner Ortiz? Commissioner Ortiz?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
All right. Thank you, everyone. Reminder, we do not meet in December. Next time we'll meet in January. Happy Thanksgiving to everybody. Happy holidays, and we'll see you next year.
Thanks for the scheduling adjustment, y'all.
Of course. Take care.